All right. All persons who have a business before the Honorable Chief Judge and Associate Judge now putting on for the District of Appeals. Draw near and give your attention. God save the United States, and it's on report. This on report is now in session. Please be seated and come to order.
Morning and welcome to the District of Columbia Court of Appeals. The court is sitting EnBanc this morning to hear the matter of Donald Trump et al. Versus E. Jean Carroll. I wanted to welcome everyone back after the new year and welcome you to our historic courthouse. As you may notice, our judges are not wearing masks on the bench, and we did that so that those of you in the audience could hear and see more clearly who is speaking and asking questions. Counsel, when you approach the podium to argue, you're at your option. Welcome to take off your mask if you choose. Just for health and safety reasons, those seated in the courtroom, we would ask that you keep your masks on during the argument. I would like to take a moment to introduce our panel of judges. I am Chief Judge Anna Blackburn-Rigsby. To my far right is Associate Judge V.J. Schenker. Seated next to him is Associate Judge John Howard, Associate Judge Roy McLeese. To my immediate right is Associate Judge Corrine Beckwith. To my left is Associate Judge Catherine Easterly, Associate Judge Joshua Deal, and Associate Judge Lauren Alikhan. This case, as you may be aware, has come to us on a certified question from the Second Circuit, United States Court of Appeals for the Second Circuit. Ms. Carroll initially filed a lawsuit in New York State Court alleging that then President Donald Trump defamed her on 3 separate occasions while responding to public allegations that she raised against him that in the early 90s, he sexually assaulted her. At issue in the underlying case here, the United States subsequently removed the case from New York State Court to the Southern District of New York Federal Court under the Federal Westfall Act, and then moved to substitute itself as the defendant to the litigation after certifying that at the time the statements were made, the then President Trump was an employee of the United States, and he had made the statements at issue while within the scope of his employment, also under the Westfall Act. Judge Kaplan of the Southern District Court of New York denied that motion, holding that Mr. Trump was neither an employee of the United States nor acting within the scope of his employment under the law of the District of Columbia. Mr. Trump then appealed to the United States Court of Appeals for the Second Circuit, and a split panel held that then President Trump was an employee of the United States within the Westfall Act. The panel determined that District of Columbia local law applied. However, the Second Circuit panel expressed uncertainty about whether this court, in determining whether an employee was acting within the scope of his or her employment, follows the traditional view of respondeat superior employment law, which focuses on the employee's motivations at the time of their tortious conduct. In other words, whether the employee actuated, at least in part, by the purpose to serve the employer. Or under the internalization view, which focuses on whether the risk to the employer of the employee committing a tort was unexpected, and it could be fairly considered the cost of doing business, such that the business should be required to internalize the cost. In consideration of this uncertainty, the Second Circuit certified this question to the District of Columbia Court of Appeals pursuant to DC Code Section 11723. This court accepted the certified question, and that's what brings us here today. Before counsel proceeds with argument, I would like to take a moment to ask council to clarify how you wish to divide your time today. Starting with counsel for Mr. Trump and counsel for the United States.
I would like to start with, we're going to be the DOJ proceed first. I will argue for 15 minutes and then we'll reserve 10 minutes for rebuttal, Mr. Mateo.
All right, thank you. Counsel for Ms. Carroll and intervener, District of Columbia.
Good morning, Your Honor. My name is Joshua Metz. I represent plaintiff appellee E.G. CARROLL. We will go first and take 35 minutes of our allotted time, leaving 10 for my friend, the Solicitor General of the District of Columbia.
Thank you. With that, I believe that we are ready to proceed with argument.
Thank you, Your Honor. May it please the court. I'm Mark Freeman for the United States, here on behalf of the Department of Justice. If the court pleases, I'd like to reserve 5 minutes of my time for rebuttal. We are here, as Your Honor noted, because the United States certified under the Westfall Act that former President Trump was acting within the scope of his federal office or employment within the meaning of this court's respondeat superior cases at the time of the statements at issue. Now, we didn't make that certification because we thought those statements were appropriate. Plainly, they are not. We made the certification instead, relying on a series of DC Circuit cases applying this court's case law in the context of defamation claims against senior elected federal officials. Those cases recognize that part of the job of a senior elected official is to be responsive to the public and the media on matters of public concern and major public controversies. And that when they do so, they generally act within the scope of their office or employment.
So, counsel, I understand you said that you made the certification decision based on DC Circuit case law. But my understanding is of the reason why we're here is to figure out what the District of Columbia's respondeat superior law is. So is it the government's position that the DC Circuit's case law and Ballinger in particular is an accurate summation of the District of Columbia's respondeat superior law?
Yes, Your Honor, that's what I was about to say, which is that we think the question essentially for this court is whether Ballinger correctly applies this court's case law. And
if I could drill down a little bit, my understanding is that the Department of Justice's understanding of Ballinger is that it is a single issue inquiry, whether or not the individual employee was acting within sort of the business enterprise of employment, right? That you don't look to the purpose.
No.
Or do you think that it's a binary inquiry? That's my question.
Yes, thank you for the opportunity to address that, Your Honor. Ballinger, just as this court's case law does, goes through the elements of the restatement second from 1958. The discussion in Ballinger notes, there's the 3 parts of the restatement, right? The first is, were you doing the kind of thing that your office involves doing? The second is, were you substantially within the authorized time and places? And the third element, this is 228, 1A, B, and C. The third element, C, is whether you were actuated, at least in part, by a desire to serve the employer.
If I may jump in, it seems to me, identified what is at the core of most of the District of Columbia's case precedent, an acknowledgement that the restatement second, each of the provisions that you cited applies. If that is the case, why is it necessary in your view that we address the Ballinger line of cases from the DC Circuit as opposed to just relying on our own precedent, which relies heavily on the restatement second, perhaps with some other elements, which I'm sure we're going to get to as part of your argument today?
Yes. So let me take that straight on. My best understanding of this court's cases is that you apply the restatement second of torts and all of the elements thereof. Now, the court has like most jurisdictions, its own gloss on the relevant elements of the case law. But that's, I think, the test under this court's cases.
Can I ask you about the third element, focusing on the purpose part of it? Ballinger says about the test generally that the test is objective. Do you agree with that? And if so, how do you reconcile it with the restatement's reference to purpose, which seems not objective, but instead subjective?
Yeah, I admit that's a difficulty, Your Honor. Let me first address where I think the objective reference comes from in this court's case law, and then how I understand that. So the objective nature of the inquiry, I think, comes out of Johnson versus Weinberg, not the first one in 1981, but the second decision in 1986. In that decision, as you know, you addressed both the meaning of respondeat superior case law and the jury instructions that were given in that case. And the court says explicitly, and this is quoted in Ballinger, quoting from Johnson versus Weinberg in 1986, that the test is an objective one. So that's where that comes from. And the court then says, and again, quoted in Ballinger, that the question is whether the intentional tort arose out of a controversy originally undertaken for the employer's benefit.
Right. I mean, I understand that Johnson too says that expressly. That seems wrong, right? I mean, given all of our other case law, and here we are on EnBanc, and that's something that we could correct, right? If you look at all of other cases, it seems very clear that we are looking at the purpose of the individual, their subjective purpose, right? And to the extent that we have made matter of law or upheld matter of law decisions, we've upheld those decisions where we've said it is totally clear that this employee is off on their personal tortious frolic, right?
I agree with that. And I agree you've applied essentially a directed verdict or judgment as a matter of law standard. And that's why I said in response to Judge McLeese that I agree that the objective label given in Weinberg and then repeated in Ballinger is a little confusing. My best understanding, for what it's worth, is that what the court meant by that is what it went on to say in the same sentence, which is that intent is inferred from all the circumstances of the case.
Well, often it's inferred,
I agree.
right? But,
I agree.
But actually, but not always, right? And that's also another sort of interesting twist in the government's reliance on Ballinger, because in Ballinger, there was actually an affidavit, right, from the congressman explaining what his motives were, right?
Correct.
Yes. I don't have anything like that in this case. And so I'm sort of wondering procedurally, well, I have a two-part question. First, to the extent that the Department of Justice certified that the former president was acting within the scope of his employment based on a purpose inquiry that was objective, if this court were to say that that's incorrect, it's a subjective inquiry, does the Department of Justice need to revisit that certification decision?
No, Your Honor, and let me take that just as a matter of Westfall Act law. The Supreme Court recognized in Osborne that the United States doesn't have to take the complaint as stated when deciding whether to make a Westfall Act certification. So the allegations of the complaint, we can disagree with the plaintiff's assessment of the facts.
For sure that you can, and I actually, I'm reluctant to delve into Westfall Act decision making, because I fully appreciate that interpretation of the Westfall Act is squarely within the exclusive jurisdiction of the federal courts, right? And I'm just talking about what our respondeat superior law is, and if our respondeat superior law requires a scope of employment inquiry that looks to subjective purpose, and if the Department of Justice was purporting to apply our respondeat superior law in making a certification decision, does that certification decision need to be revisited?
I don't think it does, Your Honor. And I would point again, if I may, to the Johnson versus Weinberg decision, the 1986 decision. And here I'm quoting or relying on a provision of that, or a part of that discussion that was requoted in this court's most recent respondeat superior case, the Blair case in 2018. This is footnote 40. The court quotes that same language about arising out of a dispute originally undertaken for the purposes of the employer. The court in Johnson versus Weinberger also recognized that when an employee is doing the job that they are hired to do, that it is fair to presume that they are at least in part acting for the employer's benefit. That's, again, right out of Johnson versus Weinberg. And if you put those two things together, we think the implication is that the President of the United States asked by the White House press corps on the White House lawn about a major public controversy is at least in part acting on behalf of the
But
employer.
I'm sorry. That sounds a lot like you're asking for us to make a determination as a matter of law that someone was acting within the scope of their employment, right? And we have never done that.
It's true that you've never done that, but if I may explain, so I agree that the court has never directed a verdict against the employer.
And we have only upheld jury verdicts saying that, right? We rely on elucidation of the facts, right? And a factual determination. And this gets me back to the second part of my question that I alluded to earlier. We don't have any facts in this case, right? We only have a bare complaint, right? We don't even have so much of an affidavit. And I understand that, from Ms. Carroll's brief that discovery has proceeded and that there are now facts to be had. So where does that leave us vis-a-vis our respondeat superior law, setting aside the Westfall Act and how that operates?
Yes, a couple different questions there, if I may take them sequentially. As to the first question regarding this court having not previously directed a verdict for the employer, I agree with that. On the other hand, this case is pretty uncommon, I think unique in this court's case law for a couple of reasons. One, as the court is aware, the way that respondeat superior cases come to you is typically that the employer is saying this person was not acting for my benefit, and the employee is saying the person was acting for the employer's benefit. In this case, you have the employer and the employee saying they were acting for the employer's benefit. And under this court's respondeat superior case law, the burden on Ms. Carroll is to adduce evidence to show that there was no intent to subjectively to serve the employer.
But that is only, counsel, if this court decides that we need to actually, once clarifying our law, apply it in this instance.
Correct.
And I'm not sure that that is the correct role or the scope of the inquiry of the certified question from the Second Circuit. We can state with more clarity if there are still areas of our law that are unclear what our respondeat superior law is, and then send it back to the Second Circuit and to the district court to conduct that factual inquiry that you're requesting. I guess, could you just state why you think it would be preferential, as I understand you saying, to actually apply the law here, not having the benefit of the full factual record or the discovery that's gone on since this case was initially filed?
Yes, Your Honor. I think it is, of course, the court's prerogative to decide how much, if at all, of the certified question to answer. So the certified question is framed in terms of application of law to fact, but I agree the court is not compelled to answer the question in those terms.
Where would our law be unclear, and what kinds of clarifications from your perspective would be helpful for you today?
I think it would be helpful if the court clarified that, if I may, that the right question is the one formulated on page 14 of the District of Columbia's brief in this case. I think the District of Columbia filed an excellent brief in the case, and on page 14 of their brief, they recognize that on the one hand, as this court recognized in Jones citing Ballinger, that it is part of the job of elected officials to address matters of public controversy, and that they may include denying questions of wrongdoing, and that it is part of the job of an elected official to retain the public trust in order to do their job better. All of that's on page 14 of the district's brief. And the district goes on to say that in their view, the former president should lose this case because he acted solely and exclusively for a personal purpose of vengeance.
Well, counsel, is that the argument by Ms. Carroll in the district, or is the argument, I'd like to get your view on the difference between 228(1)(c) and 228(2). It seems like we all agree, well, at least you, and I think Ms. Carroll, and I think the district agree that 228 is what the district has adopted. I'm not sure about your co-appellant, but we can ask them that. I think the difference really is between your reliance on the at least in part language in 1C and Ms.
The true
Carroll.
little actuated language in 2.
Actuated at least in part, and Ms. Carroll's reliance on subsection 2, which is too little actuated.
Yes.
How does that language interplay with each other?
I have a couple thoughts on that question, but just may put a period in the end of the answer to the previous question. I think the district has formulated the question correctly, and to answer your questions, Madam Chief Judge, I think if this court clarified that that is the question, that we recognize that that's part of the job, we recognize that the person may have motivations, and the question is whether he was acting solely for a personal benefit. If you clarified that, then I think that's the clarification we would look for.
So I don't want to detract from Judge Schenker's question, which I think is a good one, but are you asking for a specific respondeat superior rule as it applies to public officials?
No, Your Honor. No, the way that respondeat superior law works, as you know, is it's within the scope of employment of whom, right? Of a manager at a department store or of whatever. And the first part of Ballinger addressed 228.1A and C in different parts of the opinion. The first part of Ballinger addresses that first question: what is the kind of activity for? Is it the general kind of thing that the employee is employed to do? And as to that, the court said, for a public official, and one of those things is addressing the matters of public controversy. And that's the proposition for which this court cited Ballinger and Jones.
I'm sorry to interrupt, but I don't mean to be obtuse. I'm not understanding what it is that needs to be clarified, because I don't understand 228A1 to be subject to dispute in this case. Maybe I'm mistaken.
If it is undisputed, then I'm glad to hear it.
My understanding is the question is, what overlay does 228A3 have? And I had thought, but you've since clarified that you agree that there is a purposive inquiry to be made. And now we're asking, and now you can go back to Judge Schenker's question about what the nature of that inquiry is. Is that correct?
Well, I will be relieved to hear it if that is true. The reason why I thought that question was in dispute is at the oral argument in the Second Circuit, my friend took the position that even answering the question, denying wrongdoing simply and without any further statement would have been defamatory and out of scope.
Well, I guess I'll take it back as far as what's undisputed, as far as what our test is, right? Yes. Not applying law to facts, but I thought there was no dispute that there is a business enterprise component to our respondeat superior law. We adopted the restatement second. We moved away from employee purpose, which was the test before 1958.
Yes, if I may, I think this court has adopted the restatement, and 228.1A says, is it the kind of activity that you're generally employed to perform? And then 229 elucidates that inquiry and says, is it either the actual conduct you're employed to perform, or was it incidental to that conduct? And then it lists a series of factors which this court has applied. And we think the reason this court cited Ballinger and Jones, what it cited Ballinger for was this proposition.
And Jones isn't an absolute immunity case. And absolute immunity, you don't consider motive. So it just seems to beg I don't find it at all helpful to answer the question that we're asking here, which is, what is the purpose of inquiry? How does it work?
If Your Honor frames the question that way, I agree with you. Jones doesn't bear on it. Okay. The Jones bears on the 228A1 point about what is within the scope of what are the activities for which federal public officials act.
Right.
And that is the point for which Jones cited Ballinger. But if I'm relieved to learn that
Please return to Judge Schenker.
That sounds like
I've diverted you for far too long from Judge Schenker's question.
Yes.
So what Judge Howard was talking.
No, I was saying that sounds like a question for the fact finder to look at, as opposed to a part of our test, which brings us back to Judge Schenker's question, which I'm very interested in your answer to.
Yes, Your Honor. So two answers to that. First, I think this court has answered the anomaly, and I'm going to point to the court's decision in Blair. And second, I think the law has evolved, as you can see in the third restatement, which I just acknowledging the court has not explicitly adopted, but also the commentary on the third restatement. So let me take those two things in order. In the Blair decision, this court discussed at length and with some emphasis that the question isn't whether there was enough intent to serve the employer. The question is whether there was any intent to serve the employer. And the court goes on to say, we emphasize that it is only out of scope if it was done solely for the personal adventure of the employee. So I think that's the 2018 decision. So I think that sort of puts you on one side or the other of the restatement question. And then the second point I'll make is that is the by far pervasive view in all jurisdictions applying the restatement second. And the commentary on the relevant provision of the third restatement explains this, because the third restatement identifies this as an anomaly, an inconsistency internal to the second restatement.
Do you think 228(2) is just poorly written?
Right, 228, yes, I do think it's poorly written, because 235, I think, refers to no intention to serve the employer. And then the restatement third, I just invite you to look at the commentary on that. It says there was some inconsistency internal to the restatement second. Most courts resolved that inconsistency in favor of saying any intent to serve the employer makes the employer liable. And that is what this court did in Blair. So
assuming that's the test, can I just ask how on this record we could really answer it? I mean, what if the way that discovery developed, there were statements from President Trump saying, every one of my advisors told me to leave this alone. Don't say anything. Maybe a bare denial, but no more than that. But you know what? I wasn't going to let her get away with it. This was a scorched earth campaign. I was out to take her down. And that's the way I've lived my life. If that were the record, and it might be for all we know, I mean, we don't know how the depositions have come out. Would that still be in furtherance within the scope of his employment, do you think?
So let me answer that question in a couple of ways. I think my view would be, if you had a conclusive record that he was acting solely and exclusively for a personal purpose, then yes, he would be out of scope. But I think it'd be exceptionally rare to come to that conclusion with respect to the President of the United States answering a question from a reporter at the White House.
That might be right. I just wonder how we can answer it right now. I mean, this kind of gets back to an earlier point, which is the question about what his purposes were when making these allegedly defamatory statements seems to me like an intensely factual one, one that requires some record development. And there is now some record development, and we are not the fact finder as to that. And I just wonder why this isn't a fact question.
So it is. If I may, I'm mindful of Judge Easterly's caution to stay away from the Westfall Act. But if I may give a Westfall Act flavored answer to your question, the Westfall Act certification, as a matter of federal law, is prima facie evidence, and the plaintiff has to come forward with evidence to disprove it. And the prima facie evidence here is that he acted with at least some intent. That was the effect of the certification, applying this court's respondeat superior law. And that's consistent with Johnson versus Weinberg, because Johnson versus Weinberg recognizes that when you do the thing for which you are employed, it is presumed that you are acting at least in part for the purposes for which you're employed.
It's prima facie evidence, right? But it doesn't sort of end the day, right? And I think the Westfall Act very self-consciously incorporated state respondeat superior law. And so if we think that that is necessarily a fact determination, I am hesitant to get into sort of interpretation of the Westfall Act, but it seems like the Westfall Act has invited our factual inquiry to be a piece of this.
I agree that it is a matter of respondeat superior law of this court, and I agree that we're asking the right question. That's why I said I think at the end of the day, the District of Columbia, page 14 of its brief, puts its finger on the crux of the question. I think the reason why, if we were briefing this in federal court, we would say that as a matter of law, the plaintiff has failed to raise a material factual dispute over whether the president acted with any intent to serve the employee.
I think what Ms. Carroll would say in response, and I don't want to speak for them, but is that we have come forward with evidence specifically, or at least the egregiousness and outrageousness of the conduct here. Are you saying that that has no role in our analysis, or that it's not developed at this point factually?
No, I'm not saying that, Your Honor, but I think it's important to take a step back and realize what the form of that analysis is. What that is, and I think, Mr. Matz will speak for Ms. Carroll here. Ms. Carroll's brief also urges the court to resolve this as a matter of law. I think what's going on there is everybody here on stipulated facts is asking the court to draw inferences from aspects of the stipulated facts. Now, Ms. Carroll says the statements were so egregious, you should infer that he had no intent whatsoever to serve the employer. And our point is the point of Johnson versus Weinberg, that he was also the President of the United States at the White House during the workday, asked questions in a gaggle by the White House press corps and responding to them. And that the inference from those circumstances, which are relevant under the restatement, is that he was acting at least in part for the government's benefit.
Can I ask you about
We've used your time. I know you wanted to reserve some rebuttal.
Thank you.
I am aware, though, that a few of my colleagues may have a few more questions, so.
I was interested in following up on your reference to a Westfall flavor to your answer. And you earlier had said that in your view, for purposes of our deciding the issue that has been certified to us, or at least you seem to suggest, that there is a burden of proof that we should envisage as having been placed on Ms. Carroll. And I just want to make sure I understand what your points are there. Are you suggesting that in assessing whether the issue that has been certified to us is one that we can decide as a matter of law under DC law, we should be applying the burdens that would apply in the Westfall Act proceeding in federal court?
No, our bottom line submission is this, that the question, we think the court can address it as a matter of law. So first, as a top line matter, we think the court can address it as a matter of law, as Ms. Carroll also argues, drawing inferences from the facts that are presented to the court. But if the court feels unprepared to do that in this case, then we would urge the court to make the clarification of District of Columbia law that I discussed with the Chief Judge earlier.
Just to follow up, I'm not sure I got a direct answer to the
sorry.
question I was asking, though, which is, or do you think, if we're trying to figure out, can we answer this question as a matter of law?
Yeah.
Should we be influenced in any way by a flavor of Westfall Act procedures about who would have what burdens under the Westfall Act?
We're not
Or
asking you to do
instead
that.
we think about what DC law would procedurally ordinarily permit us to answer.
Yeah, we're not asking you to do that in this case. And if I just may explain why, that is apply a Westfall Act flavor. And if I may explain why, the way that this works out in federal court, this is not a problem for this court to decide here. I just want you to understand the context. The way that Westfall Act certifications play out in federal court is, of course, they are an immunity for federal employees, right? So, you know, if I were to defame someone standing at the podium today and the Attorney General certified that I was acting within the scope of my federal employment in doing so, I am immune. I am out of the case, and the plaintiff has a claim against the United States. The operation of that as a matter of federal law, it tends to happen at the motion to dismiss stage, as this happened in this case.
Not always.
Not always.
Right?
Not always.
I mean, in fact, in Majano, right, DC Circuit decision, the court reversed a summary judgment ruling and said, go back. And the district court had an evidentiary hearing, right? Put people on the stand, made credibility determinations about what people's motives and purposes were.
I agree with you, Your
So
Honor.
it's not inappropriate. I mean, not that we should be looking at how the Westfall Act works, but it's certainly not forbidden to do that.
I didn't mean to suggest it was forbidden. What I was just trying to explain is the way this normally works in litigation.
Can
Yes.
I just ask, you mentioned when we were talking about 228A3 and its interaction with 228.2. Sorry, I got my numbers and letters
it's counterintuitive
confused, but
to me
you're
also,
following
yes.
along, so I
Yeah.
appreciate it. And you mentioned Blair,
Mhm.
and you said, well, in that case, the court said that it could not be determined as a matter of law that the person was solely acting out of their own tortious purposes,
Mhm.
right? But does it matter that what we said was, this is a matter for the jury, right? This can't be determined by judges as a matter of law. We leave it to a fact finder. And, you know, so do we interpret this purposive inquiry under the restatement with this procedural gloss of always leaving it to juries unless you can determine as a matter of law that this individual was acting out of their own malicious, tortious motives? Does that make sense?
I think I understand your question. And I think the answer is yes, but let me make sure I follow. Your question, as I understand it, is Blair didn't hold that the officer was per se acting within the scope of his employment. Blair
Correct.
held.
And we have never done that.
Agreed. And as I explained, though, the court has one, and I don't know why it would have held that it is never appropriate on uncontested record to direct a verdict the other direction. And two, the court has never confronted a case like this one where the employer is in front of you saying, yes, the person was acting for our benefit, and the employee is arguing the
But,
opposite.
you know, Justice Scalia said in Jordan, you almost never would direct a verdict in that direction because the very nature of an intentional tort suggests a personal motivation.
Well, that is true, but on the other hand, there is a subset of cases, Your Honor, where I suspect employers.
I don't disagree with you that it's certainly conceivable.
Yeah.
I mean, I can imagine cases where the intentional tort is clearly, you know, the employer directed him to, you know, repossess that car, and if the guy gives you any guff, you punch him in his face, right? Then you'd have a very clear direction.
But if I may, I think the
Sure.
court's law actually goes a little farther than that, which
Uh-huh.
is that there's a subset of intentional tort cases in this court's case law. I'm thinking here of cases like Heckinger, maybe Johnson also, in which an employee is concededly doing the thing that they are employed to do. And then the conduct evolves, that someone loses their temper and they go too far and commit a tort. And in those circumstances, I think this court almost invariably reverses directed verdicts, saying the employer was not liable, recognizes that the person can be liable. And that's because that's the most common circumstance for an intentional tort. The other thing I will say is—
But I'm sorry, just to interject. I mean, in Heckinger, we recognize that the employer could be held, this could be within the scope of employment, but we don't go so far as to say, well, because we see that it's in part motivated or by a desire to serve the employer, we're directing a verdict or holding as a matter of law the other way. I mean,
I agree.
we invariably leave this to the fact finder. It seems almost like a substantive element that we allow, 12 citizens to decide, is this something that we want employers to be held liable? Because we're doing a balancing inquiry anyway.
Respectfully, Your Honor, I disagree with that. Suppose the employer in Heckinger had come into you with a stipulated fact, said, I understand that the manager, when he pushed the employee and he fell and hurt his head, was trying to help me.
It could be lying.
What's that?
I mean, but he could be lying. You have to take that at face value.
No, just that it's the employer who is the one who's disputing his own liability. And if you had the employer
Well,
coming
I'm
in.
sorry, there wouldn't be a case in Heckinger. The employer wouldn't have been litigating.
Well, exactly.
they-
And if I may, that's why this court hasn't had cases directing verdicts for finding conduct to be within scope. Because I think in every case of which I'm aware, you have the employer saying, I have factual things I want to argue about why it was not within scope. And here we are arguing that we think an
Counsel,
elected.
in this case, if we look to Judge Calabrese's separate opinion in the Second Circuit, you're arguing unique circumstances here because the employer, the United States, wants to take responsibility essentially and liability, but the impact essentially could be, since there is no, the United States has not waived immunity.
Correct, yes.
For defamation cases, that there would be no recovery. It sort of almost seems counterintuitive to some of the purposes of the Westfall Act, which are to allow recovery for a victim of an action, a tortious act of an employee of the government, to get recovery from the government as opposed to the individual employee who might not have any means to fund a recovery. But here, there would be potentially no such recovery because the United States is immune from liability in defamation cases. So that's, I mean, you're not you personally, but you're making it sound as if the employer here is doing something magnanimous, but it could have, as we'll hear more from Ms. Carroll, the result that she might not be entitled to any recovery. But
I appreciate that point. If I may just make one point about that. The United States employs a lot of people in the district, and it's true the United States Congress has not waived the government's sovereign immunity for defamation. But the United States is liable every day of the week for intentional torts, particularly those committed by law enforcement officers, with FBI, DEA, police, federal police all over the district. They are liable the United States is liable for intentional torts committed in their scope of employment. And the test that I'm advocating to you today is a test that would govern in those cases as well.
well, thank you. We're going to give you additional time for a rebuttal because we've taken you over your time, but I would like to hear from other counsel at this time.
Thank you, Your Honor.
Good morning, almost afternoon. Alina Haba, I represent former President Donald Trump in this matter. I want to thank my colleague. He did such a great job of going through the restatement and all those details. So I'll try and address something more on point for my client in particular, which is the question that I feel is before this court today, which is whether a president is acting within the scope of his employment when he speaks to the American people to publicly defend himself against a false accusation. I think this was addressed by the Supreme Court, and we can all recognize that the Supreme Court is binding and acknowledged that there exists a great public interest in having a president with the maximum ability to deal fearlessly with the American people when he is addressed questions in his official duty from his official office.
Ms. Haba, I think it would be helpful if you would tell us, and I would have asked Mr. Freeman this as well. Does your perception of our respondeat superior law differ from that of the government's, or do you have the same view of it and Ballinger's role in it in particular?
I think I will kind of get away from the minutia that we talked about with sitting in the District of Columbia Court of Appeals. The reason that I think we're all struggling here is because this is a Westfall Act case that was decided in New York, that he is an employee of the government as the president. That was the first step to that inquiry. So I don't think we go into it. I'm happy to step by step go through the three prongs and explain how even under the traditional test of the restatement, my client would still fall within the scope of his employment.
But counsel,
Are you disputing that we are a second restatement jurisdiction?
No, I'm stating that the facts of this case, there's no question that this is a second restatement jurisdiction.
counsel, I think there's some question because in your reply brief, you said this court has consistently adopted an internalization approach. So.
Well, even under that approach, Your Honor, I
know,
think,
but that, okay, even under that approach, but which is it? Are we an internalization jurisdiction or are we a restatement jurisdiction and do we need to clarify that?
I don't see a reason, frankly, to clarify it. I think this district has been very clear and this court has been very clear on what you are, and then that's a restatement approach.
I don't understand the statement in your reply brief that we're consistently an internalization jurisdiction. So
I believe that came, frankly, from a response to the court's order where they analyzed, for some reason, traditional versus internalization approach. If you look at the judges, I think he went on for quite a bit about that and the distinction. We don't really see it as relevant, to be honest. Under the restatement, President Trump was acting within the scope of his employment. So even in this court, he should be immune.
Is there any situation in which a president speaking to the press would not be acting, in your view, within the scope of his employment?
I think in this particular court, with the case law that has been mentioned by counsel, this was thrust upon him and he was responding to press in his job. That, I think, is the distinction.
But like as a bright line rule, basically, in any circumstance where in the middle of the day he's taking questions from the press, doesn't matter what he says, it falls within your understanding of the application of the restatement in this jurisdiction?
Yes, because my understanding would be that intent is not relevant as long as you're responding in within the scope of your employment.
Well, so let's take it back to that. I understand under 228A, we're looking at, is this of the kind he's employed to perform? Mm-hmm. And that's what you keep coming back to. And I think we don't dispute that A is satisfied here. I think what we're struggling with is C. So, I mean, are you saying that anytime one is engaging in conduct that falls under A, they necessarily satisfy C?
No, I think that under this, if we even went through the steps, under C, it's actuated at least in part by the purpose to serve the master. So here, the conduct is only outside of the scope of employment if it was done solely to accomplish a personal goal. That was not the case with my client.
How do we know that?
Because
all we have is a complaint.
Correct.
Right? Where allegations have been made. And at least in our court, if we were looking at respondeat superior and how it applied at this juncture, we would look at the complaint in the light most favorable to the plaintiff. And I can't think of a single case where we would say, oh, we're going to decide the respondeat superior issue on a bare complaint. we at least need to have discovery. We'll at least go to summary judgment. And even then, we're going to let the jury decide this unless we can say for sure that this individual was acting out of their private, personal, tortious motives. So how does our case law and our treatment map on to where you are procedurally right now?
If we were going through the steps in C, all he had to do was have that the statements be at least in part, I believe is the standard here.
But my question is, how do we know? You're at the time that Judge Kaplan made this decision, your client hadn't said anything about this. There was no proof, no evidence put forward, no proffer made about what your client's intent was or was not.
I think there is proof, respectfully. He was on the front lawn being asked questions. He answered those questions. That is proof that he was solely doing it to respond and for his purpose of his job.
So the fact, and this gets back to Judge Ali Khan's question, the fact that he was operating within the scope of his employment in the time and space, right, satisfying 228(1)(a) and B, right, that from that we just infer that C is satisfied as well?
No, I think that the press asking him an inquiry shows that it's an issue of public concern, and it was an issue of public concern for a president, whether he did in fact do the false accusations that Ms. Carroll has put out there. It became an issue of public concern, let's remember, Your Honor, because Ms. Carroll chose to bring these claims while he was president.
Let's go back to Judge Deal's hypothetical.
Sure.
No, and the hypothetical is everyone is telling him, don't say anything. This is not within the public interest. This is not within your interest in maintaining your authority as president. And he says, forget it. I'm doing this for my own personal purposes. I'm going to get this woman and I'm going to take her down because of my own personal malice towards her, right?
And that would be the case if he just came out by his own volition and went up to the podium and started bashing Ms. Carroll as they.
No, that's my hypothetical. They're saying, don't answer any questions about this. And he says, no, I'm going to answer some questions. And I'm going to do it for these reasons, these personal, malicious, privately tortious reasons.
Mm-hmm. So your question then goes to something that puts me a little bit in a rock and a hard place here. This is why the Westfall Act exists. This is why these courts, all due respect, don't answer this issue. And it has answered this issue and in Jones and looked at and Blair and looked at Ballinger because there's a case on point in this state.
Ms. Haba, I think you said the question sort of put you in a rock and a hard place, and maybe that goes to what your initial statement was. I get the sense you don't feel that you should be here in this court addressing this question.
I don't. Yeah, that's correct, Your Honor.
But we find ourselves all here addressing these questions,
yes,
which have been certified to us by the United States Court of Appeals for the Second Circuit. And so we are also grappling with what our appropriate role is here. You seem to be suggesting that their law of the District of Columbia on respondeat superior and when an employer is vicariously liable for the tortious acts of their employee is clear enough from your perspective. But yet we've been asked to clarify some things here. Are you asking us to adopt the Ballinger line of cases, essentially saying public officials, you're not asking for a special rule, I think was Judge Ali Khan's question, for public officials. You are asking what exactly?
I am asking this court not to create a new law in this court, but to reference the cases on point in this state in federal court, which directly address the situation. We have the law. I'm asking this court to just affirm it, as it did in Blair. In this situation, this situation was thrust upon the president.
Right, Blair, we had a little different situation because we did have a affidavit. We don't have a factual record at all, which is unlike most appeals that would come before this court. We don't have we have a record of the proceedings in the federal court under the Westfall Act. And I think our colleague Judge McLeese asked you about the interaction, or asked your co-counsel about the interaction or interplay between our role in interpreting Westfall Act, if we have one, versus our role in stating what the law of the District of Columbia is. And then we have to decide whether or not to apply it here, absent the typical factual record, as a matter of law, or whether to send it back to either the district court or to the circuit for further proceedings.
Right. I think you're stating it far more eloquently, frankly, Your Honor, than I could ever state it. We are dealing with the Westfall Act issue in the state court, and that is exactly why I find this argument incredibly difficult, but also frankly simple. We should be applying, just as the New York, Southern District of New York and Second Circuit had corrected the Westfall Act. We've already established that he's an employee of the government. He was a sitting president. The entire purpose, and this is one thing we haven't discussed, Your Honor, the entire purpose behind this is that presidents can't be afraid to answer questions from the podium, from the front lawn.
You're coming back. You keep coming back, and I just want to understand your answer to the questions. I think in response to the question, is this actuated by a purpose to serve his employer? What I hear you saying is something like, all of his answers were responsive to questions that were put to him. So there's not a bright line test that if he's at a press conference, anything he says goes. But if he's responsive to questions that are roughly related to of public interest, well, then that's within the scope of his employment. Is that the position?
Yes, I think if he...
Can I just ask sort of the counterfactual then? Let's assume that doesn't happen. Let's assume that he's at a press conference and at the end of it, he says, just to conclude, I know nobody asked me, but, Steve Wynn, he makes shoddy hotels. His buildings are decrepit and I would never stay at Trump hotels, and then departs. Would you think, so that's at a press conference, no questions posed to him. How would you think of that? Would you think that was within the scope of his employment?
No, it serves no purpose. There was no public interest in that. So
Okay.
I would not say so.
So that your dividing line is sort of responsive to a question that is of public interest. Is that roughly it?
I think that is, Your Honor. Also, I think that your cases in this court have shown that there is a very important question on whether this was thrust upon the person or whether they willingly just went out, as we've seen with police officers who were off duty, who attacked people. And that was handled by this court and said, look, that's different than this situation. He is responding to a false allegation. And then he was again asked about it because it was an issue of public concern.
Can I ask you, I want to get back to one of the themes in your brief, and one of the themes today is that if this court were to conclude that this conduct was not within the scope of employment, that would be bad as a policy matter because presidents wouldn't be able to respond fearlessly. And your opponents actually make a kind of the flip side argument, which is if we end up determining that this was within the scope of employment, then Ms. Carroll will be left without a remedy, and that would be bad. And I'm wondering whether either of those considerations is properly relevant to what we're deciding. Those are all consequences of the Westfall Act. Choices that the Westfall Act attaches to conclusions we might reach about state law. But I'm wondering whether we should, as we're trying to figure out what DC law tells us about whether this is within or without of the scope of authority as a matter of DC law, we should be influenced by whatever federal choices were made statutorily about what that would mean either for presidents, if we went one way, or for defamation plaintiffs if it went another. So do you think that's relevant to our state law decision, or do you think that's really shouldn't be relevant to our state law decision?
I'm not sure I understand the question, Your Honor. Is the Westfall Act relevant to our decision here because it is not applicable in state court? Is that? Well,
another way of putting it is whatever we decide about what kind of the structure or application of respondeat superior law in the district will be applied in the district. Not in Westfall Act cases primarily, every once in a while, maybe in Westfall Act cases, but it'll also be applied in the district. And it functions very differently in the district. It doesn't end up like a determination that something is within the scope of employment doesn't normally immunize the individual employee. It just is another possible defendant. And it also doesn't typically end up, the contrary determination doesn't normally preclude liability altogether. It leaves the individual plaintiff in place. So although in this dispute, as a matter of federal law, our answer to the DC law question will have the various consequences that people discuss and have arguments about whether they're good or bad, depending on their perspective. But I'm just wondering whether any of that is relevant at all, or whether we should just decide a question of DC law and, let the chips fall as they may, as a matter of what federal law has decided the consequences of our state law application, without considering that broader context of state law principles of respondeat superior.
I think we should absolutely defer to federal law. I think that the federal law is in place and handles this particularly very narrow issue with presidents. And that's why the Westfall Act exists. So I understand that we were asked.
Congress just revised the Westfall Act to impose its own respondeat superior test, whether it's the second restatement or internalization or the third restatement. I mean, it seems like the Congress made a very intentional choice to incorporate state law, and that state law is 50 states plus the district, and that's going to vary depending on where the president is sued. So I guess I share the same concern of Judge McLeese, and maybe I'll be more express about it. It seems like Congress, having put the burden on us to say what the state law is, it seems like we should do that without consideration to how it would play out in this, minute category of federal cases under the Westfall Act.
Even if you applied the state law, Your Honor, I think we land in the same spot, which is that he was acting within the scope of his employment. And as we went through the three prongs, I'm happy to go through all three, but.
So under the third prong,
Right.
Mr. Trump has made similar statements, I understand, since leaving office. Were those actuated, at least in part, by a purpose to serve the American public?
That is a different case, Your Honor, that I don't really feel is appropriate, frankly, to speak to. It's a different set of facts. I think that there is a difference when you are sitting as the president, and there are certain protections that are put in place for a sitting president.
So it
versus
seems
a
to me
normal
that it is relevant to this case because I'm trying to figure out what the difference is between A and C. And you've told me that once you satisfied A, that doesn't relieve you of C. So C has to be doing some independent work, regardless of whether someone is making the statements, during their time of employ, during their hours of employ. So it would be helpful if you could just provide me
Sure.
a ballpark, whether you think that when he makes these statements, no longer being president, he is serving any master.
Sure. I think under both cases, since you'd like me to address them both, they're both defamation. Let's take just the defamation portion. I assume you're ignoring the ASA portion of New York. But for defamation in both cases, there's a different situation, but I think you come out the same way. In both cases, we had let's go with the first one, the case that we have in front of us today. He was a sitting president, so the Westfall Act applies. We've already gotten that determination that he was an employee of the government. And then you go through, frankly, in my opinion, the Westfall Act analysis, as in Ballinger, which was on point. Then if you look at the new case, let's call it CARROLL number 2, he is a former president. He is a candidate for presidency, and he has addressed, again, a new allegation, frankly, an old allegation under a different law, but the same allegation, which he denies vehemently, which is incredibly concerning, not only to him and his family, but to the constituents and the people of the United States. He has an obligation to respond to them. And quite honestly, as anybody would, if somebody falsely accuses you of rape, you would respond.
But he doesn't have an employer at this point, right? This sounds similar to the Swalwell case that where the United States takes the opposite position. As I understood their position, I think it was Swalwell. I think, was it Meadows involved? I can't remember. No, it was Mo Brooks. That's right. And they said, well, look, this is campaign activity. Campaign activity is not anything that's in furtherance of the United States interest. They wouldn't certify that as under the Westfall Act. One perfectly acceptable answer might be, sure, he has a strong, maybe even a predominant personal interest in denying these allegations. But at least while president, he also had an interest in serving the public and making sure he could discharge his roles as president effectively. And you can't do that with allegations like this hanging over the head. So that now that he's no longer the president, maybe it is all personal. I know you don't want to give that answer, but I guess I think this goes back to Judge Schenker's earlier question, which is, my understanding is you could concede that his predominant interest was a personal one in making these statements. Do you have a view on the degree to which they need to be motivated by his interest in serving his employer? Judge Schenker pointed out some tension between 1C and 2, where 1 seems to say if it's in any part, if there's even sort of a minuscule part to serve the employer, that's enough to be within the scope of employment. And then later it says, well, you know, it can't be too little. It needs to be something measurable or some word like that. Do you have a view on that?
I think the view on that is that it needs to be in some part, the restatement has said, it needs to be in some part for the employer when we're looking at respondeat superior. I think that when you look at, the difference between the traditional test and looking at whether or not you're going to, the internalization test, for instance, you have a different analysis there. I think that as long as you're not veering off and completely out of line and have nothing to do with your employment, I think it's very clear cut. You have to have some purpose in all of these cases. And just to bring it back to this one point, these are defamation cases. His statements are opinion. So even if you get past all of that, it's an opinion that he stated. Didn't bash her.
I think we want to stick with respondeat superior. And I guess drilling down on what Judge Steele was just asking, I mean, do you think that if the motivation is, 99.99% personal, but 0.01% in the interest of the employer, that puts it into the scope of employment box?
I do. I think that's part of the
Doesn't
risk.
that get us to effectively an internalization scheme that we don't have?
And especially because we're getting to that 0.01% based purely on the fact that this is the president of the United States and nothing more, right?
All due respect, I don't even think we would get that far because the Westfall Act applies because it's the president of the United States. So
Well, we're trying to.
that's why I
stick
struggle with the.
and not to sound like a broken record, but
Right.
we're really trying to stick with DC law, right? Because
Okay.
why would you want our court to decide what the scope of the job of the president of the United States is, right? There are 50, as Judge Ali Khan observed, there are 50 states plus the District of Columbia, a federal city, right, with courts who decide what their respondeat superior doctrine is, right? And within that doctrine, I don't think you want state courts and the District of Columbia court deciding what the job of the president is, right? But we do decide what our doctrine is. So going back to my question, 99.99% personal, but 0.01% in the interest of the employer. You think that suffices under our test?
I think that you would need to know the facts of the case as you've indicated. I don't think this is that situation, but I do see what you're saying, which is the slippery slope. But again, that's why we have separate policies and procedures for presidents of the United States.
Right.
So
Ms. Haba, I didn't mean to interject, but we have eaten up
yes,
all of the rebuttal time for final counsel. Is there any final statement? And are there colleagues who have a final question for you who haven't had an opportunity to ask? Anyone?
I have just one short clarification question. So I heard this, but it seemed like you vacillated from it. Is it your position that as long as anyone calling themselves press asks a question that is then immunizing, it's put it within that scope of employment?
I'm sorry, I couldn't hear you, Your Honor. Is it my position that anyone?
Is it your position? I heard you state this at one point and then it seemed like you vacillated a little bit. Is it your position that at any point a president, or we can say politicians in generally, are asked a question by someone that is calling themselves the press? Because I understand the White House certifies the press that comes to them, and presidents often talk with members of the media, may even get advice from them and then appear on their programs and do art, take interviews from them and whatnot. As long as someone is calling themselves the press, if they ask the question, if it had been put to the politician, then it is the employer. It now fits that public purpose.
Fits the public purpose. I would take it even further, Your Honor. I think that even if it's a constituent, not just the press, that's asking the president a question, and you're a congressman, I think you have an obligation as a government employee who represents people, let alone the single executive branch, to answer those questions. Yes.
Thank you. Any other questions? All right. Thank you, Ms. Howard.
Thank you.
Mr.
May it please the court. My name is Joshua Metz. I represent plaintiff appellee E. Jean Carroll. To answer the certified question, the court need only reaffirm and apply its long-standing second restatement rule of respondeat superior, which confirms, as Judges Kaplan and Chin found, that Mr. Trump was acting outside the scope of his employment in defaming Ms. Carroll because he did so for personal reasons rather than to further the interests of the United States.
Mr. Metz, how do you respond to the reply brief arguments of Ms. Haba that we actually have moved in the direction more of the internalization theory of respondeat superior? Because in some of our cases, like Johnson, we have mentioned this term foreseeability, and that therefore some have understood that to mean that we might possibly be moving in a different direction away from the restatement. Is that your position?
It's not. I think Ms. Haba is mistaken. And in a number of cases, Blair and Bamidel are the most recent examples. We give a number of others in our brief. This court has recognized that there was kind of a moment in the late 1970s and early 1980s where it moved closer to something like what Judge Calabresi called an internalization view. It has since reaffirmed time and again, starting with Boykin and Carone and Brown, Blair, Bamidel, one after the other. And the DC Circuit recognized this first in the Jacobs case and then again in 1995 in the Hadding case, that this court has really anchored itself on the second restatement approach where foreseeability is relevant to the analysis, I think largely in the sense that it bears on 228(1)(a), which is the on-duty requirement.
Going toward the intent or purpose of the employee's actions.
No, so what I was saying is the foreseeability idea has come to, I think, be understood as part of the question of whether the employee was on duty, was doing the kind of thing that they're supposed to do, which is 228(1)(a), and that the purpose requirement, which is 228(1)(c) and 228(2), has been understood as a separate analysis. And in thinking about how to apply that here, I actually, if the court will allow me, I'd like to walk through a few points about what the record is before the court and how the court might approach it, because obviously there were a lot of questions about that came up. And I think it may inform how the court addresses the question as certified by the Second Circuit. So, and this is mostly Westfall Act law, but these are principles that I believe the government is unlikely to disagree with. And so the plaintiff may, when the government certifies that someone acted within the scope of their employment, that creates a prima facie case that person was within the scope of their employment. The Supreme Court held in Gutierrez de Martinez de Lamongo that a plaintiff may seek to challenge that certification in court, as we did here. The plaintiff may rebut that certification
in federal court.
In federal court, yes.
And I hope as you walk us through this, it's very helpful that you'll talk about how that interplays with our role with respect to the Westfall Act, and if we may interpret it, if we may avoid it and stick only to our own law's jurisdiction.
I promise I will address that question. So if a case is filed in state court and a tort case against a government employee, the government can remove it to federal court through a certification from the Attorney General. They were acting within the scope of their employment. That certification is prima facie evidence that they were. The plaintiff is free to challenge the certification. They are free to challenge it in sole reliance on the allegations in the complaint. And that's Wooderick versus Murtha and Stokes versus Cross, both DC Circuit cases. When they do so, the allegations in the complaint are taken as true for purposes of resolving the threshold question of whether the scope of employment certification was correct. Further discovery.
If I could just pause, that's also a difference between what the court is doing versus what the Attorney General is doing, correct? Because as Mr. Freeman suggested, the Attorney General does not have to take the allegations as true when deciding whether or not it's within the scope of the employment.
That's correct, but the Attorney General can and has in a number of cases previously attached an affidavit or some other evidence to the certification where they want to explain perhaps why they have certified. And obviously the Justice Department made a choice not to do that after Mr. Trump solicited the certification from them. And when the plaintiff relies on the allegations in the complaint to seek to rebut the scope of employment certification, the district court has discretion to authorize further discovery if they believe there is a factual dispute bearing on whether the scope of employment certification was proper. Here, Mr. Trump, we sought discovery at the outset of the proceedings. Mr. Trump and the Justice Department adamantly insisted none was necessary, and they adhered to that position in both their district court and the Second Circuit briefs. And the Second Circuit stated at 772, the parties do not dispute the facts underlying the allegedly tortious conduct.
The discovery has since unfolded.
That's correct, but that discovery was not discovery on the scope of employment issue, although it could potentially have some indirect bearing on it. It was discovery on the merits of the case. The last point I make about how the record works here is where a plaintiff relies on the allegations in their complaint to rebut an attorney general certification. Not only are those allegations taken as true, but where there's a choice made, as was made here by Mr. Trump and the Justice Department, not to put in any evidence in response, those allegations are read in the light most favorable to the plaintiff on something like the 12b6 standard. Wuderick versus Murtha and Jacobs versus Vrobel, both from the DC Circuit in 2009 and 2013, respectively, confirm that. And so at this procedural posture, and I realize it's an unusual one, it is a question of law, whether on the basis of the undisputed factual record, with all inferences drawn in our favor, we have successfully rebutted a prima facie case from the Justice Department that Mr. Trump was acting within the scope of his employment.
But I mean, they say on the undisputed facts, there is evidence that he was acting with a purpose to serve his employer. Namely, he was engaged in press conferences, answering direct questions from the press of a matter of public interest. So, I mean, let me just present to you the flip side of the question I asked to opposing counsel. What if the record revealed in this case, record that we don't have yet, that Mr. Trump, all of his advisors say to him, you have to nip this in the bud. The only way you're going to be able to govern effectively is to bury this immediately. And the only way to do that with an accusation like this is to do everything you can to discredit Ms. Carroll. If we had a record like that, do you think that would be within the scope of his employment?
We had that record, and there were, say, one further fact, which is that Mr. Trump said, you're right, I'm going to go do it for those reasons. I'd pack my hat and go home. But that's not this case. And what I want to highlight for your honors is that the record in front of the court, I realize that you would ordinarily address a matter like this on a more comprehensive record. The reason you don't have one is because Mr. Trump and the Justice Department made a strategic choice not to allow the creation of one and to instead seek to win this motion on the sole basis of the allegations in the complaint with inferences drawn in our favor.
But that happens all the time, and courts deny those motions and say we need more factual development on this case. I mean, I don't think they're married to the position that they win as a matter of law. If they're wrong about that, it doesn't mean that we pick which side wins as a matter of law. Sometimes there are just underlying questions of fact that the court needs to resolve. And one fact that I don't think we know much about is what, the critical one under 1C is to what extent were his responses to questions actuated by a purpose to serve his, whoever we want to call his employer, his constituents, the American public, something like that. I mean, that fact's just totally missing.
Judge, can I make 2 points on that?
Sure.
And I want to get to the second one, it's important, but just on the first point I'd like to make is, as Mr. Freeman will undoubtedly remind the court when he gets up, because they certified that Mr. Trump was within the scope of his employment, we do have the obligation with the inferences drawn in our favor from our own factual allegations to show that he wasn't. It's a weird thing. So the burden is on us, but we get all of the inferences. And so in order to even get to discovery, we would need to at least make that showing. So the court would have to think that there were some kind of dispute. But here's the second point, and it's the important one. I do think that we have made adequate factual allegations for the court to conclude, drawing inferences in our favor, that Mr. Trump was motivated by personal reasons rather than job-related reasons.
When you say adequate, you mean sufficient to compel a conclusion as a matter of law rather than to require a fact finder to resolve a disputed issue? Is that what you mean? Or what do you mean when you say adequate?
You're right to ask the question because I'm trying to have it both ways. I do think it is sufficient to justify a conclusion as a matter of law, which is what Judge Kaplan found and which is what Judge Chin would have found in his dissent in the Second Circuit. It is within the prerogative of the courts hearing this case to say that we think more discovery is required, in which case it would go to a fact finder. But I have to tell you, we have not found any case anywhere in which this scope of employment determination under the Westfall Act went to a jury.
And what does the complaint say? At the complaint, I'm not sure the complaint is in the record that we have so far. It's definitely in the appendix in the Second Circuit, so it's publicly available. But can you be specific about what, in your view, are the allegations in the complaint that are sufficient to establish the former president was acting within the scope of authority when he made the allegedly defamatory statements at issue?
Absolutely. Obviously, we laid these out in our brief as well. If we need to, we're happy to provide a copy of the complaint in a supplemental filing with this court. I thought it would come over with the certified record. But we rely on a couple key points. And then I'll explain why I think Mr. Trump and the Justice Department are mistaken in suggesting that the fact that he was on duty sort of by itself supports an inference that he was acting with a public purpose. If you look at his statements, there are several features of them that take this, I think, well outside the norm, even for Mr. Trump during his tenure in office. The first is that we're not talking, Judge Deal referenced this earlier, about a denial or I never did it and I never met her. That's a version of what happened in the Jones versus Clinton case, where I might add, nobody seemed to think a Westfall certification was on the table. Right, we don't have that.
Counsel, we wouldn't even have a tort in that situation, right? So we wouldn't be here, or at least arguably we wouldn't have a tort.
Well, Ms. Jones thought you would, and the district court in that case in the Eighth Circuit agreed with her for purposes of resolving the absolute immunity issue, and then the Supreme Court resolved the question of the adequacy of the defamation claim in its opinion in that case. But her fourth defamation claim in that case was based on denial and saying it never happened, I never met her, and other sort of statements to that effect. Here, the statements go well beyond that. There's Judge Chin highlighted at oral argument in the Second Circuit and in his dissent the fact that in his third statement, Mr. Trump, I think very bluntly implied that she was too unattractive for him to have sexually assaulted her. That he said in his second statement that she or implied very strongly that she had been paid off by third parties.
So I don't want to interrupt you midstream, but I'm going to, so my apologies. I guess in assessing these statements, it's helpful to know what the quantum is to satisfy actuated, at least in part. As I understand our case law, we might be a mere iota jurisdiction. So if it is the 0.01% to serve the American public and 99.9% to serve his own personal gain, that still might qualify as satisfying 1C. Is that your view of the quantum? And do you think you can, meet that hurdle?
Yes and yes. I will say courts are not in the business in general of defining sort of fractions of fractions when it comes to motive. And so although the court in a number of cases, including the Bamadel case, which was just a couple of years before Blair, used the too little actuated standard, and that really seemed to drive the analysis, as Judge Kaplan pointed out in his district court opinion here. And then in Blair, it says, no, it's really, if even an iota of motive was job related, that's enough. As I think as practical reality, as people who live in the world and try to make inferences about each other's motives, the difference between those things can be slight. I'm unaware of any case from this court or any court relying on this court's authority that has seen that distinction as the one that drove the difference in outcome in a case. And I do believe here, it would be a little peculiar to have a hyper expansive view of respondeat superior when the entire animating principle of the respondeat superior doctrine is the premise that an employer controls their employee and can in some respect be held accountable for the things that they do, presumably on behalf of the employer. And here, as both Judge Chin and as Judge Kaplan noted, there is no control in that sense of the term on behalf of like the American public at large over the president. And so there's sort of this weird mismatch, you might think, between which in our view was a reason why you wouldn't even apply the Westfall Act to the president, but
right. I mean, that's
disagreed, and so here we are. And so in thinking about how you do that analysis, we think it would be strange to have a hyper expansive view, but even if you do.
But we don't, yes, that is an oddity of this case, no doubt. But we don't want it to distort our respondeat superior law, right? And so we are trying to figure out how do you strike the balance, right? And within our conception of respondeat superior, where we're trying to hold employers liable, employers, right? Regular Joe employers in the District of Columbia, right? Laundromat owners and moving companies. And, this is what our concern is, right? And we want to hold them responsible when they do have some responsibility over the employee and some control. And we don't want to hold them responsible when the employees that they have are off on their own, intentionally malicious, tortious frolic, right? And so what is the measure of purpose that we should be applying?
I think that the proper measure of purpose is the too little actuated standard, but we think that we prevail even under the any iota standard. And let me explain why, because candidly, there's not going to be that much of a distinction in the explanations as to why we believe we would prevail under either standard. And the court has generally adhered to the any iota standard, and that is what the third restatement says. And so if the court believes that's the proper test, it can in some circumstances come awfully close to internalization. But we think that we prevail under it regardless, because here we have a highly unusual factual record. It's unusual in a number of ways.
I hope you'll get back to the answer to Judge McLeese's question about the facts here that you think are sufficient for us to make a determination at this stage as a matter of law.
Yes, Your Honor, that's exactly where I was going. And Judge McLeese, I apologize for not getting back to it sooner. The facts that we think here are especially striking are certain objective features of the statements that were made, the kind of inflammatory, shocking personal character. It is not, if someone says you raped me and I say, well, you're too unattractive for me to have raped you, that suggests something more than business as usual in terms of the business of the government of the United States.
That's not exactly what he said.
That's not exactly what he said. You're right.
Just to be clear.
You're right, I'm embellishing, but when someone accuses a prominent official of sexually assaulting them and they respond and say, well, she's not my type. Our position is that is evidence of some degree of motivation that goes beyond the job related, accusing her of having been paid off, of engaging in some kind of conspiracy, of having falsely accused others on the basis of absolutely nothing whatsoever. That's one set of considerations, Judge McLeese, but there's more. The second is that there's a prior history of dealings between these two people that is deeply personal in character. And there is a line of authority which indicates that where there is that kind of previous course of dealings, which was absent in a number of cases where someone was held to be inside the scope of employment, where there's that personal history, it's more reasonable to infer that there was personal motivation. And that's particularly true as there's a long line of cases in New York holding that where there's a kind of, where that history involves sexual misconduct, that often does tend to be more personal in nature. And here, of course, that sexual misconduct predated his time in office. The third factor that we would point to is the modus operandi consideration. And this court has a long line of cases in which it's highlighted that where there's sort of a pattern of conduct with similar seeming intent across them, you can infer that intent tracks across. And here, Mr. Trump, as alleged in the complaint at paragraphs, I think 117 to 124, has a long history, both before taking office and as it turns out, since taking office, of engaging in precisely these kinds of highly personal attacks on women who credibly accuse him of having engaged in sexual misconduct. And where you see somebody before, during, and after the presidency engaging in very similar conduct, even if, as Ms. Habas suggests, he's doing it now for the greater good of the American people, that tends to suggest that the motivation is not really anything relating to their job. That's just how they roll.
So
that's their MO.
Can you give me a situation involving this president and at least factors 2 and 3, which I think would be existent regardless of point 1 that you made, where this president could have answered this question in a way that would have been defamation in your client's view, because otherwise, again, we wouldn't be here in the first place, but would also be within the scope of his employment?
Sure. I actually think that if he had made some of these statements, and again, I want to preface that answer with this point, if it's okay. This is not about editing his statement, although it will feel like that's what I'm about to do. Because the question is not, courts policing what presidents say. It's where the question is, on the face of his statements, where can you infer a particular subjective motive? So we're relying on the statements and the circumstances around that to make that inference. If he hadn't said some of the stuff that he had said, the inference would be much weaker. So for example, if he hadn't had the comment about her not being his type, if he hadn't had the suggestion that she had been paid off by third parties, if it were merely, I didn't do it and I've never met her before, and look, she's out there selling a book, you could imagine. I think I would have a much harder case, and my instinct is it would be very hard to persuade a court that those statements on their face are a sufficient circumstantial evidence to support an inference of a personal motivation.
And I want to get back to sufficient to support an inference, because that seems as though it wouldn't be the ordinary way in which this court, if it were phrased with this question as a question of DC law in ordinary procedural settings, would be assessing things. And one way of looking at it is the information that you were just describing in the complaint and the inferences you're arguing from them sufficient that it would be correct as a matter of law to grant a pre-discovery motion to dismiss? And if that is that the right question? Or do you think for some reason that's not the right question procedurally for us because of the flavor of the Westfall Act or because of something else?
Yes. This is not like most procedural postures that a court would encounter. We have, I think, collectively experienced it as about as strange as you probably are. What the Westfall Act indicates here is that it is our burden to overcome the prima facie case established by the certification, and we can overcome it if relying on the factual allegations in our complaint, drawing all inferences in our favor.
I'm with you on all of what the Westfall
Act. We show that it's
Act,
private. So I think it's probably something. I mean, it's weird to attach a word like preponderance to it, But courts have treated this as a purely legal determination time and again.
Let me just clarify my question, because I'm with you on, I mean, I think I understand everything you said about the way the Westfall Act works. I think I largely agree with the procedural structure you outlined, as it's my understanding of the Westfall Act. Not that, we have any special expertise in that topic, obviously. But we have a certified question, and we're only going to answer questions of DC law. Well, we're only going to answer questions of law for sure. To the extent we have any expertise that's special, it's going to be about DC law, not about the Westfall Act. And so one way of looking at how we should try to answer the question that might be helpful to the federal courts who are going to have to do additional Westfall Act kind of work and maybe substantive work is to set it procedurally the way I was describing, which is the way this case comes procedurally most analogously to what we are used to is we don't have discovery. There are allegations in a complaint and there are responses in filings. And the question is, as a matter of law, is there an answer about scope of employment? And the procedural analog that comes to mind, at least, or one that comes to mind is, okay, well, would we, if the trial court in a superior court matter had granted a motion to dismiss pre-discovery, would we uphold that or not uphold it? And if our answer is no, we wouldn't uphold it, then maybe our answer to the Second Circuit should be that we can't answer as a matter of DC law definitively a scope of employment question is applied to these circumstances, because our procedures wouldn't allow us to give you a definitive legal answer. So you need to go off and do more Westfall Act work. But what we can do maybe is tell you some things about DC law to try to clarify what seems to have been a point of uncertainty, so that as folks go off and do the additional work that is required, they will get the benefit of our effort to try to clarify our law to the extent it's unclear. Is that an incorrect way of looking at things? And if so, why?
I wouldn't call it incorrect, Judge McLeese. I do think, but it's not what I would propose. And let me explain why. I do think it is an option for this court, of course, because on certification, it is within this court's authority to reframe the question as it comes to you and to give whatever answer on the law or facts you see fit. And so, yes, the court could simply send the Second Circuit a response that says something like, we have clarified, you seem unclear as to whether our body of law is about internalization or there was second restatement, which was the primary part of Judge Calabresi's analysis. We can clarify that for you. Here's our answer. You can apply that. We can't apply that to the facts here and reach the scope of employment question, because that's not procedurally a thing we do. I don't think that's what this court should do, however, if I may. And if I can offer a few reasons for why I do think the court should answer the certified question as it comes to the court. And again, that certified question does pose specifically the scope of employment issue. The first reason is that there is a number of federal court cases that purport to be applying DC law to resolving factual circumstances somewhat analogous to this one. And it would be, I think, an appropriate exercise of this court's role to clarify, not just, hey, we follow the second restatement, but here's what it looks like to do that in a circumstance like this, so that other courts applying DC law understand how DC law should function. The second reason to do it is that the Second Circuit wasn't just unsure about whether this court follows internalization or the second restatement. I argued that case as well, and I can represent you, and if you've listened to the argument, you will have seen this. Judges, all three judges, Chin, Nardini, and Calabresi, had a lot of questions about how this court under DC law would apply that standard and what this court means by personal and job-related motives. The third reason, and there's four of them, so I'm almost done. The third reason is that this case has gone on for quite some time. The parties are, of an advanced age and looking for a resolution to the case. And Judge Kaplan has concluded multiple times that Mr. Trump has acted with bad faith and in dilatory ways designed to prolong a resolution of these proceedings. And if the court were to pursue your option, Judge McLeese, I frankly worry it could take years to get to a resolution. And the final reason that I'll offer is that answering the certified question as presented would be consistent with this court's precedent. I would point the court to its very first decision on a certification, which was the Penn Mutual Life Insurance Company versus Abramson case from 1987. And then a somewhat more recent EnBanc decision in Washington Metro Area Transit Authority versus Johnson from 1999. Both cases in which this court addressed not just sort of a pure question of law, but something that felt like a bit more of a question of law in fact, and reached the ultimate issue. And we think doing so here makes sense because someone, and that person is going to be a judge, is going to have to answer the question of whether we have adequately rebutted the certification by the Attorney General. And they will be applying DC law when they do that. And DC law will provide the only governing framework for that analysis. And we think that this court is as well situated as any other to clarify both what DC law is and how it would apply in these circumstances.
Counsel, maybe,
Can I take you back to the genesis of the Second Circuit's confusion, which is whether we are a second restatement jurisdiction or an internalization jurisdiction? And I'm wondering, it seems like our cases do tease out foreseeability, not just in that sort of temporal period where you think we may have been on a bit of a frolic and detour. And I guess, is your argument that any notion of foreseeability, whether it's direct outgrowth or mere opportunity, is actually a function of A1, or do you think that actually is something, or sorry, 1A, or do you think that's something that's happening in 1C?
As I read these cases, the court's cases, it has primarily looked at that function in the context of the 1A analysis, whether, in thinking about whether something is.
And of course, it
perceived,
comes in under 1D too, right?
Yes, in cases
where
involving
there's use of force, which may be the source of the confusion to start.
Exactly. And there are distinct doctrines that relate to the use of force. But I think the foreseeability idea, it sort of, as applied to the subjective motive analysis, frankly, it doesn't make a lot of sense because the 1C inquiry, as defined by this court in its cases, and we lay this out in our brief, focuses not, Ballinger used that phrase objective, and Mr. Freeman, of course, addressed that. It's a subjective analysis. The question is, why did that person in their circumstances do the thing they did? And part of what you're asking, and this is an important distinction that I think my friends allied, is even if you were on duty, and there's case after case that says this, even if you were on duty, even if you were within authorized space and time limits, even if you're doing the kind of thing that looks like the thing a person in your job would do, you can still have acted for reasons that were not meant to serve your employer. That is the whole premise of that third factor under the restatement. And when you take foreseeability and try to merge it into the intent analysis, it essentially writes that out of the equation, which is what I'm afraid my friends on the other side are doing. What they want to say is whenever the president or another senior or elected official is doing something in a place that kind of looks like the time and place they would do a federal job, you can automatically infer a job-related motive. And that is nothing less than a request that this court write out for a category of people, the intent analysis, that in every other circumstance is a freestanding requirement of this court's analysis, and that Congress would have known full well was part of this analysis when it adopted respondeat superior as the rule of decision.
but I don't think there's.
Sorry, part of the problem though, right, is that we have only decided cases as a matter of law where we've said it is totally clear, not just that this was, actuated to some degree, it was actuated in whole, right, by personal, private, tortious motives. But on the flip side, we've said, otherwise, if we think that it's possibly mixed motive, jury question, right? And so, I think we really do need to clarify what it means to have purpose to some degree. And I tried to ask this question of Mr. Freeman, and I think I didn't ask it very well. So I'll try again. Does our purpose to some degree, to what degree analysis, is that affected by the fact that we generally leave this to juries, right? Does that reality, that procedural reality, inform the quantum of purpose that is required such that we could say, well, clearly, if it's only 0.1% motivated by a desire to assist the employer, that is not going to take it out of the scope of employment, right? Does that make sense?
It does make
Mr.
sense.
Freeman, if that is a better question for you when you come
I
back
want
to
to
the
preempt
podium.
him by saying, I think it does make sense. I assume he's going to agree, right? I do think it makes sense for the court to think that in general, where you're really talking about what might be fractions of motives, that's something we think of as a classic fact issue. And here we have given the court, I believe, a lot of reasons to think that Mr. Trump was acting and making these statements on the basis of personal motives, and that this went way beyond subjectively in his own mind any desire to serve the interests of the people of the United States or to simply assure people of his fitness for office. Because if you think it does, you sort of risk a circumstance where anyone who says something critical of a public official is at risk of open season on them with essentially complete immunity, which has never been understood to be the law. And if you're talking about fractions of motives, if the question is, well, can you infer from the fact that it was at the White House and that he was the president at the time and that a reporter asked him, that everything he said in response must have been in furtherance of a job-related purpose. You are, in my mind, in that world of, well, gosh, that's a pretty thin inference to draw. Judge Schenker made this point that they're really relying on inferences from circumstance there. And that may usually be a jury fact question. Inconveniently, I think the Westfall Act makes it a question of law because it is a question of law whether we have adequately rebutted the Attorney General's certification. And it has to be a question of law because sending it to a jury would make little sense where the goal of the Westfall Act is to define the bounds of immunity.
Now here I'm a little puzzled because I thought that some of the Westfall Act cases treat it as a question of fact, but just a question of preliminary fact that is resolved by a motion in advance and sometimes might require an evidentiary hearing and a factual determination by the judge as a fact finder. Are you saying that the question of the scope of employment question as it relates to the validity of a Westfall Act certification is always a question of law and not ever a question of fact for a judge as fact finder?
No, I'm saying that's a correct. It is a mixed question of law and fact because scope of employment always involves applying a legal standard to a factual record. Here, the factual record is undisputed. And my friends on the other side have been adamant from the beginning that there can't be
factual record. What seems to be a key fact, which is what was the subjective motivation of the former president in making these statements, seems to me very much disputed. And the question is, people are taking some facts that are alleged on an incomplete record and trying to argue each of them in their own side that as a matter of law, those facts the few facts that we have to work with right now, as a matter of law, dictate an answer favorable to them on what seems like a disputed central, maybe essential factual question of the subjective intent of the former president. So,
and I think there's I think that there's a legal way to resolve that, which is, and I would look at Jacobs versus Frobel, DC Circuit 2013, and Woodrick versus Murtha, DC Circuit 2009, where the Justice Department and the federal tortfeasor make a choice not to offer evidence and not to undertake discovery. The plaintiff is allowed to rely on the allegations in their complaint with inferences drawn in our favor. And what my friends on the other side are asking the court to do after conceding that they're really asking for an inference from the circumstances of the facts alleged is they're asking you to draw inferences in their favor. And having made a strategic choice not to open discovery, and I can imagine why Mr. Trump would not have wanted discovery on these issues, having made that strategic choice, they have to live with it.
So, Mr. Matz, part of what's a little topsy-turvy in this case that makes it unique is we have the employer, the United States, saying, you know, don't worry, to the victim of the alleged tort. We take responsibility as the employer. Normally, you would have just the opposite. And we have the you as counsel for Ms. Carroll saying the opposite of what we usually hear. We don't want this to be in the scope of employment, which you would normally be arguing so that the United States could take responsibility. But we know in this circumstance that that may not happen, likely because of the immunity that the United States would have for defamation claims. And I guess that, in my mind, makes it a little difficult to conceptualize what's being said. You know, it seems like in the normal course of things, and I don't mean to put words in your mouth, you can tell me if I'm wrong, you might be making a different argument that of course, this was in the scope of employment, as Ms. Haba said, and we want recompense from the United States government to take responsibility for these actions. I don't know if you have any.
I do have a response. Because
it seems a little tortured sometimes for us to be able to make credibility determinations, essentially, about what you say is the factual record for us.
Of course. Let me try to address the sort of weird remedial scheme that we're describing and then turn to the record point, right? And Judge Calabresi talked about this in his concurrence in the Second Circuit as well. You know, it would ordinarily be the case that a lawyer representing a victim of misconduct, you know, would seek to include the person who committed that misconduct within the scope of employment. And there's no denying that in many cases in the private sector, that's the pattern you'd see. And in many states, courts have held as a matter of law that sexual misconduct in the workplace or related tortious acts are outside the scope of employment as a matter of law. This court has in some circumstances allowed for the possibility that they're within the scope of employment. That's the Brown versus Agenwright case where it went to a jury. Here we're in this unusual situation where him being within the scope of employment gets rid of any potential recovery because the United States has not waived its sovereign immunity. And I think what in my mind comes from that is the following point. The United States and Congress in writing the Westfall Act was focused enough on the tort of defamation and on a kind of tort by tort, employer by employee way of thinking about this, that in designing a rule of immunity, they could have adopted a view much closer to the ones that my friends on the other side described. Judge Ali Khan made a version of this point earlier. Congress could have simply said after the Westfall decision, we're just not going to allow tort immunity for federal employees ever, or we're going to have a federal standard for, it's going to be the second restatement as a matter of federal law, or we're just not going to allow immunity for defamation. They singled out defamation to not waive sovereign immunity. They could have singled out defamation as a tort for which you were just always at a loss. It didn't matter within what, Instead, they made a choice to put this decision to state courts within this Westfall Act framework and to say, we are going to allow a recovery and we're going to take state law as the measure of that. And Judge McLeese made the point, we don't therefore think state law should be distorted by the ensuing equities that the government has, I think, made a big deal of in this case of, what about the dangers to federal officials of allowing immunity? What about the dangers that we highlight to victims of not allowing immunity, right? The government made a choice to sort of let the chips fall where they may under ordinary state law respondeat superior. And so this court's job here, its role here, as I understand it under the Westfall Act, is to simply announce and apply the law of the district to the facts here. And the Westfall Act asks this court to do it. And this, well, really the Second Circuit has asked this court to do it in an anomalous procedural posture, where the record before you consists of our complaint and allegations, and inferences are drawn in our favor. And the question is whether we've adequately shown that there was a private motive and not a public motive under the restatement 228 standard. Usually this court would not reach a decision like that at this stage of the case. Usually a president would not have inadvertently, I assume, or maybe intentionally waived their absolute immunity. At the outset of a case like this, we're going to be filing a brief in the Southern District of New York in 2 days where we explain how they waive their absolute immunity. So you wouldn't necessarily even end up in a situation like this.
Ask you, is it a fair characterization of your analysis that, contrary to my understanding of your opponent's argument, you think that we should take the question certified to us and grind through the facts and the allegations and the like through the prism of the procedures specified by the Westfall Act? And if those end up meaning that because of who contested what when, that would procedurally permit a court to rule as a matter of law, if it were a federal court grinding through the Westfall Act procedures, we should rule in your client's favor as a matter of law, rather than kind of taking the case and looking at it through the prism of the procedures we would normally apply before answering a bottom line question of law and scope of immunity under kind of our own normal procedures. Is that a fair, or is that what you're asking us to do?
It is fair. And the question as certified, I mean, you all have it in front of you, is under the laws of the district were the allegedly libelous public statements made during his term in office by the President of the United States denying allegations of misconduct with regard to events prior to the term of office within the scope of his employment. So the certified question was not just, does the District of Columbia follow an internalization approach versus a second restatement approach? It is that question.
And so, counsel, if we answer that question and we apply the law of the facts and rule in your favor, and the next day, the deposition in this case reveals that President Trump, former President Trump, as my colleagues hypothesized, says, I was doing this to benefit the country and it's the only way I could govern, and I have to deal with foreign leaders on a daily basis, and I can't have these allegations hanging over my head. Your response is too bad, too late?
Well, that's one of two responses I have. So the first response I have is yes, this is a defense that the Justice Department and Mr. Trump have made a choice, and they've kept on making it repeatedly, not to engage in discovery, not to put in an affidavit like in Ballinger, not to introduce evidence, but to take this record knowing full well that the legal standard where they don't put in evidence is that our complaint is taken as true. And those are the facts that matter for this decision. That's the first response. But the second is that we have completed fact and I believe expert discovery in the CARROLL 1 action. There is a protective order in place that prohibits me from saying a great deal. But what I will say is that I don't expect that the hypothetical Your Honor described is especially likely to occur.
Can I ask you about the government's certification decision? Counsel?
Yes.
Do you think that the government made a purposive assessment that is consistent with your understanding of our law under the restatement under 1C?
I'm not in a position to explain what the government's internal decision-making here was. It was publicly reported that Mr. Trump and his sort of solicited this.
Based on the way that this has been litigated and briefed by the Department of Justice, would you say that they made an internalization decision, assessment of respondeat superior and certified thereon? Or do you think that they walked through, this was within the scope of employment incidental thereto, time and space, and at least partially with the purpose of benefiting the employer, and that's why we're certifying?
So being respectful of the deliberative process protections of the Justice Department, what I would say is based on their filings in this case, where they have sought to explain and defend their certification, they made that certification based on a very aggressive reading of the Ballinger case that in my view is probably a bit further toward an internalization, something like an internalization approach for federal officials.
That's how I read their brief, is that they pretty much read out the purposive inquiry in their characterization of Ballinger. And so my question is, if that's what they did, should their certification be relied upon? I mean, this kind of just goes back to this question about whether or not we should be making a decision about applying the law to the facts, even if they've, waived an opportunity to put more facts into the record. Do we have a certification decision from the Department of Justice that should be relied upon, or should we give them another opportunity in light of any clarification this court makes about its respondeat superior law to revisit that decision?
Sure. 2 points. The first is based on their filings in this case and in the Second Circuit, where they relied on, for example, Smith versus Clinton, which was a case where there wasn't any purpose element at all, allegation involved. I think it's pretty clear that DOJ has taken the position, even if they deny it, that what they're asking for is something like an internalization or categorical approach. Mr. Trump is explicit on that in both his opening and his reply brief. If that was the basis on which they arrived at the certification decision, and it turns out they misunderstood district law in doing so, in my mind, that's not a reason to give them another bite at the apple. And Mr. Freeman has said today that he wouldn't take it even if he were offered it. It's a reason instead to reject the certification and allow the case to proceed in the ordinary course. And I'm unaware of a circumstance where the Justice Department declined to withdraw a certification, which they can do. It's happened before. There are a number of cases that come to mind where they've withdrawn certifications, where they decline to do that and adhere to it, and their motion to substitute fails. I think at that point, having made a strategic choice to proceed without discovery, without an affidavit, without more of a record, and to sort of go on that path, which has been supported by Mr. Trump at every turn, I think the result would be that Mr. Trump cannot avail himself of the protections of the Westfall Act in that circumstance.
All right, Mr. Matz, we've taken a lot of your time and given you some extra time. I don't know if there are any final questions from my colleagues. If not, Ms. Van Zyl.
Thank you, Your Honors.
Thank you.
Good morning, Your Honors. Caroline Van Zyl on behalf of the District of Columbia. Again and again, in their briefs and in the argument before this court, President Trump and the Department of Justice returned to a single
Ms.
theme.
Van Zyl, I'm sorry, I'm having a little trouble hearing you. I don't know.
Let me see. Is that any better?
Thank you.
Excellent. All right, trying again. Over and over in this case, both in their briefs and in the argument before this court, the Department of Justice and President Trump returned to a single theme, that speaking to the press is part of the job of a president and an obligation of the office. And as we've been discussing here, that is true, but it's only half of the story. I think as this court well understands, the crucial question here under district tort law, even if an employee is doing something that is part of the job, is motive. And in answering that question in this case, this court should do what it has always done. It should consider all the facts and circumstances of the case, and it should ask what the employee's motive was
at the moment the tort was
Are
committed.
we able to do that at this juncture with the case in this posture, in your view? And if so, what do we rely on particularly for motive?
Well, respectfully, Your Honor, I agree with my colleague, Mr. Batts, in that respect. All that you have here is the complaint. Under Jacobs versus Robel, you apply the ordinary 12B standard. You take all the facts and the allegations in the complaint is true, and you draw all inferences in favor of Ms. Carroll. And I think when you do that, again, applying this court's traditional respondeat superior analysis, looking to the motive at the moment some of these statements were made, it becomes very clear that the inference has to be that these statements were made with a personal motive, out of a selfish motive. And I think my colleague, Mr. Matz, has outlined many of the factors here in this very robust complaint that lead to that inference. I would simply note that those factors strike me as very similar to what the DC Circuit addressed in Jacobs versus Medley, where you had, in that case, some pretty outrageous conduct. There it was bringing a gun to a dispute with a tenant. You also had a history of personal animosity and earlier, quote, personal altercation and name calling. And you also had a likely, quote, personal reaction to insult and abuse. And I would submit
counsel,
that
with all those facts out there potentially and inferred from the record, same question everyone else has been asked. How would you characterize the quantum that we need to look at?
well, I also would agree with my colleague, Mr. Matz, in that I don't know that it matters. I do tend to agree with the government and with the third restatement that if these statements were to any degree actuated by a purpose to serve the interests of the United States, then they are within the scope of employment. But I just think, given the unrebutted facts in the complaint here, you can't infer that purpose. Not only do we have the circumstances and the content of the statements themselves, which I'll reiterate, contain the statement, I'll say it with great respect. Number one, she's not my type, implying the plaintiff not only is unattractive, but too unattractive to rape, but also some fairly wild and untrue allegations. Again, we have to assume that they're untrue about being paid to say these things, about accusing other men.
So outside of the wildness of that, how do you then, I mean, I get it. It sounds extreme. How
Right.
do you then get past the public interest piece and the fact that the president was responding, the former president was responding to press?
Well, first, I would make just a factual point, and then I have a legal point as well. The factual point is the first statement here was actually a press release. It wasn't a response to a particular inquiry from a reporter. It wasn't, in that sense, thrust upon the president. It was sua sponte, and I think that in some sense that does matter. And then in terms of the public interest component, I would note that not every court that has considered defamatory statements made by politicians in an effort to undermine an opponent has automatically found that that comes within the scope of employment. And I would point this court to a case called Ennis versus Krenka from the highest court of Maryland. As this court knows, we draw our common law from the common law of Maryland. So those cases tend to be particularly persuasive. And in that case, the court said a politician's, quote, public statements were made to discredit the plaintiff and other political opponents in order to protect her career as an elected official. And it held that that was outside the scope of employment because just protecting your career, that undifferentiated purpose, isn't enough to be a purpose to serve the government. And I would submit that that's really, if you're going to make a friendly inference in President Trump's favor, that's the only friendly inference you can make here.
Well, can I ask, one point that Mr. Metz made is we can take into account the modus operandi of the defendant, of Mr. Trump. And I take it he meant that to say, well, look, he's always lobbed personal attacks like this, both before and after office. What if I told you that in conducting his professional affairs, in conducting direct business for the government, he would also lob personal attacks at his political opponents, so that the modus operandi might even cut in his favor, that even when he's talking about, critics in the Congress or people that he wants to attack, he uses this sort of personal attacks as leverage. Does that cut in his favor?
Well, if he had put it in an affidavit, to that effect, that he does that not to further his own personal interests, but to further the interests of the United States, maybe that would get him there. I don't know that that cuts in his favor here, particularly where we have to draw all inferences in Ms. Carroll's favor. And indeed, I mean, if this court is prepared to go to a point where it says anytime you are tearing down a political opponent or someone who has said something less than favorable about you to the press, that is automatically inferentially within the scope of employment. I mean, that is quite a thing to say. I mean, that would be to say that had President Trump in these circumstances said not only that Ms. Carroll was too unattractive to assault, but had added that she's a criminal, she's a liar, and you'll find evidence of it all in her house. And his supporters had torn apart her house. Perhaps she'd been indicted for this alleged criminal behavior, that would all fall within the scope of employment, in effect saying that all serves the interest, was intended to serve the interests of the United States. And I would just submit that regardless of whether he has a pattern of doing this, and regardless of whether hypothetically in some scenario, perhaps he views that as a motive for serving the interests of the United States, there has to be a line that you draw, and there has to be, perhaps more importantly, some evidence to indicate that that's what he was doing in this scenario when these tortious statements were made.
Why you say what the rationale is for your statement that all inferences, while we're deciding the question we've been asked to decide, we should be drawing all inferences in Ms. Carroll's favor. That's some principle of DC law. Is that your view that we should be grinding through that question by applying the structure of the Westfall Act into the detailed procedures of this case up to this point? What's your theory behind that statement?
Yeah, that is straight from Jacobs versus Vogel at page 220, which is a federal Westfall Act case. Candidly, I think if this case were in an ordinary, DCCA posture, it would go to a jury. And so it is a little bit uncomfortable here that because of the Westfall Act, you don't have that option. In essence, it sort of backs whatever jurist is going to decide this question into a bit of a corner.
Well, why don't we have the option of saying, we don't really apply the Westfall Act ordinarily, and we've been certified a question of state law, and we can opine on some state law questions, but the question of exactly how the Westfall Act would process this case procedurally is an intricate question of the Westfall Act, which the parties frankly haven't really briefed for us. There's been discussion of it today, but it hasn't been briefed in detail. And so we're not going to bite that off. We're going to say that we've been asked a question of DC law. Under DC procedures, we wouldn't be able to give you a definitive answer, but here are our thoughts about what seems to be, as far as we can on the facts, we'll try to clarify what we can. Why are we backed into a corner that doesn't include that route out of the corner?
Well, let me clarify there, because I do agree with my colleague, Mr. Matz, that this is a certified question. The court can do what it will insofar as how far it wants to go in answering that question. I would think, though, that at the very least, what would be the most helpful, not only in this case, but in all of the other cases that federal courts are deciding on state law, is to at least say, well, all we have here is a complaint. Under 12B, would or wouldn't we let the complaint proceed? And if the answer is we would let the complaint proceed, I tend to read the Westfall Act cases as saying that's enough. You no longer substitute the United States. But if the Second Circuit were to disagree with that, well, they have the option of doing something else, remanding for a fact-finding hearing. But again, I do think both this court and the DC Circuit and the Second Circuit have pointed to some confusion in this court's cases. And certainly there's no case on all fours addressing defamation in a posture involving a public official. And so I think to really delve into the facts here and explain how that 1C factor of motive would apply here would be incredibly helpful. And I think one of the points that it would be very helpful for this court to make is that the broad brush and liberal brush which you paint with when you're looking at the 1A inquiry, whether this is the kind of conduct that the president or anyone else is expected to do in their job, that broad brush doesn't apply to the 1C inquiry. It is a subjective inquiry about motive at the moment the tort was committed.
You said we always do that, and I guess it wasn't so clear to me that we have always insisted on the subjective motivation at the moment of the tort. Some of our cases and some DC Circuit cases relying on them seemed instead to take this sort of arising out of idea that if there's originally a dispute where the employee starts with a motive to benefit the employer, and as a direct outgrowth of that, there is an intentional tort, that there might be respondeat superior liability, even if that at the moment of that exact tort, there no longer was a subjective purpose to benefit the employer. Do you disagree that sometimes our cases seem to have reflected that view? Or do you, which seems contrary to your statement that we have always required subjective intent at the moment of the intentional tort?
Well, I do think that there is some inartful language in some of the Johnson cases that does get repeated, but in Johnson too, the court was actually very clear that the tort still needed to be, to some extent, motivated by a purpose to serve the employer, even if you look at that case broadly and might think that it paints with a bit of a broader brush. And I do think that there has been a bit of a special rule applied to cases involving customer service disputes. Johnson too sort of makes clear that in those cases, because we're looking at the conduct, the kind of conduct that an employee might do rather broadly. Again, this is out of the restatement. You do start with this assumption that if someone is just doing their job, that presumably they are intending to further their employer's interests. If you have nothing more, I do think that's where you are. The fact is, in this case, we have so much on the other side rebutting that presumption that the president was just doing.
That's an outgrowth of the customer service cases, or do you think that's the operation of 1D? Because the customer service cases are all cases where force is used. And so perhaps it makes sense when you're talking about whether the use of force is not unexpectable, that it could be a reasonable outgrowth.
Yeah, I think it could be affiliated with 1D. I think it has snuck into some of the 1C analysis, and I think that that is improper, both under some of this court's earlier cases, like the MJU line case, and under the restatement itself. MJU line, I think, is squarely in line with the second restatement in saying that that's the case with where the hockey player raises his stick to injure another player, and the court said in that case that the hockey player may have been, at the moment when he struck the blow, completely indifferent to the work he was employed to do and actuated only by anger or hostility towards the man he tried to injure. And so, in other words, under 1C, going all the way back to the 1940s, the question really is, in that moment, in the moment here that President Trump says something like, "She's not my type," or accuses Ms. Carroll of being paid to say false things about him, or of falsely accusing other men of raping her. If we assume all that is false, right? In the moment when those things were said, were they done to further the interests of the United States? And the district tends to agree with Judge Chin that they simply were not.
You mentioned that you wanted some additional clarification, or you thought it might be helpful if we could illuminate further our case law and our thinking on 1A. Did I understand you correctly? In addition to 1C.
I did not mean to say that, Your Honor.
I may have misunderstood.
I think it is helpful to disaggregate 1A from 1C and to explain that the tenor and the approach to those inquiries is very different. I do think that that would be helpful. And I think in terms of the work that 1C is doing, it really is independent work. As the third restatement points out.
Did you use foreseeability when you're looking at 1C to say whether or not it's foreseeable in some way that this is the kind of work that the employee was tasked to do or could be expected to encounter as part of their work?
I don't think so, Your Honor, because I think that is squarely a 1A inquiry. I think foreseeability, as this court has interpreted it.
Sorry, 1A, when we're talking about the type of
work,
yes.
Right. That is a broad inquiry. This court has said it's liberally construed.
If it's in 1A, then what's the point of 1D? if 1A requires foreseeability always, then 1D, which says intentional torts require foreseeability roughly, or words may be equivalent, maybe you'll say they're different. So I'm a little puzzled about where you think foreseeability fits in the picture under the second restatement.
Well, look, if this court wants to take foreseeability out of 1A, I would say we would not necessarily object. But I think the way that it has been inserted into 1A is because the 1A inquiry encompasses not just core job duties, but anything incidental. And the court has read incidental to mean essentially the same as foreseeable, the kind of thing you could be expected to do within the course of your job, even if it's not sort of black letter within the contours of your contract.
I read your brief to suggest that on the district's view, foreseeability is a general requirement, not just in intentional torts, but it's sort of a general requirement under a proper understanding of the second restatement. Am I correct that that was the position you took in your brief, or did I misunderstand?
No, I think it is part of the inquiry under 1A. That's how I read this court's cases.
Again, in a sense, a requirement or part of the inquiry?
That it be foreseeable. I think that there are some cases where, because the job duties will be very express, you don't really need foreseeability as a proxy. I mean, by definition, those job duties would also be foreseeable if they are part of what you have been expressly hired to do. And so I think that might be a distinction without a difference, respectfully, Judge.
Well, what I'm focused on is page 6 of your brief, where it says, through decades of case law, this court has distilled the restatement factors to 2 principal requirements. To fall within the scope of employment, the tortious activity must, 1, be actuated at least in part, and 2, must also be foreseeable to the employer. So I had taken your brief to take the view that you could really simplify the restatement into a 2-component test. And so maybe I'm reading too much into that passage, but.
No, well, that is a direct quote from this court's case, Bemidele. So I think we're taking the court at its word. And if the question is, do we have any quarrel with foreseeability being a requirement? We certainly don't. We think that it's
just to be clear, the questions we asked the parties to brief were including, how should we clarify the law of the district? And I took your brief to not just be quoting, here's what you think your law is, but this was, I thought, the district's position about, here's the right understanding of the second restatement. Here's what we want you to hold Court of Appeals about the test, and it's this. So is that the district's position? If you were having us write what you think we should say to clarify, should we say this, which is, it's really a 2-part, it boils down to a 2-part test, which is, subjective purpose clarified to mean at the moment of the actual intentional tort. And second, it has to be foreseeable to the employer. Is that the district's position, or am I reading too much into what was said here?
Yes, that we would absolutely be comfortable with that. We are very comfortable with the current state of the law. Again, perhaps there are some ways in which it could be clarified, but I do read this court to be, sorry.
No, I'm sorry.
I do read this court to be very faithfully adhering to the second restatement with, perhaps a few areas in which it liberalizes to be a bit more plaintiff friendly, but I don't think that the 1C inquiry is one of those respects. I think this court has adopted a very black letter approach consistent with, say, illustration 3 in the second restatement. And this is from section 235, where in that circumstance, so the restatement really do tease this motive component out from what is the kind of conduct that someone is employed to do. And in this illustration, railroad asks its employee to eject trespassers from a freight train. And that employee does, in fact, eject a would-be trespasser because the trespasser refused to pay him a bribe. And so again, if you're just looking at that conduct through the 1A lens, is it the kind of thing that the employee was employed to do? Does it look like it's furthering the employer's interests?
So let me ask you, one of the things I thought was interesting, unless I heard it wrong, that Mr. Metz brought up, that I've been thinking about throughout the argument, was this idea of the foreseeability, like you're talking about in the master's control. It was really brought up while we were discussing more of the Westfall factors, but under this restatement, and I could see very much a policy purpose behind it, Because sometimes I look at our cases and I think we're kind of a second restatement plus jurisdiction. So with foreseeability and looking at master's control, does the fact that, should we consider the master's control and the fact that a president or a politician exists fairly outside of control in a defined scope of duties, does that change the quantum on that 1A or 1C, which in my view would probably make it less of an any iota whatsoever kind of analysis?
In our view, it doesn't really change the inquiry. And I think in our view, the idea of control is baked into the purpose test. The authors of the third restatement say that part of the work that the purpose test is doing is to sift out those scenarios where the employer does have control, can take steps to deter certain conduct, from scenarios where the employer really effectively has no control. Because if an employee is motivated solely by their own purposes, be it malice, be it lining their own pockets, as in that illustration I just mentioned, there's really nothing that the employer can do to effectively control or deter. And so I think
So if the employer doesn't have the control, then does that mean that we don't need much quanta? Does it lower the threshold for the quanta of personal purpose needed to establish that this was a lark?
I don't know that it does. I mean, I think part of the purpose of the Westfall Act incorporating state respondeat superior court law was to treat the United States and its employees the same as you would treat any other employee and employer within the jurisdiction. And I do think that if you just apply that same black letter law to this inquiry, particularly under the 12B standard, given the facts alleged in the complaint, applying that same law, it's very clear that this conduct was not done to further the interests of the United States as opposed to Donald Trump.
Can I ask just one clarifying question about the procedural posture and your view on it? I think I heard you, but maybe you'll correct me, to say that Jacobs v. Vrobel basically says we sort of treat this as a motion, kind of the same, applying the same standard as we would to a motion to dismiss. Would this complaint survive? And I understand Jacobs v. Vrobel to say, if not, well, then the suit can be dismissed. But if so, I don't see anything in Jacobs v. Vrobel saying the United States falls out of the case. And there are cases like Mahano, where the DC Circuit said that gets to a jury. Now, in practice, I think it actually goes to a judge, but that was a summary judgment case. So there had been some factual development at summary judgment. Trial court granted summary judgment in favor of the United States. DC Circuit said, no, there's a fact issue. Take it to a plenary record to a fact finder. Can you reconcile? I mean, maybe I misunderstood what you meant to say about Jacobs v. Vrobel, but why do you think that sort of, if this complaint survives a motion to dismiss, that the United States falls out of the case?
Well, I think, again, I agree with my colleague that it's due to the particular circumstances of this case. I don't think it would be impossible to say, go back, have a fact-finding hearing before the district court judge. I just think in these circumstances, it's unnecessary because there was an opportunity for the United States, as it did in Ballinger, to put in an affidavit, having some facts to weigh on the other side as to what President Trump's motive was at the moment he made the statements.
But what if both parties thought, look, these facts can only lead to one conclusion? In your view, that this is purely personal, in their view, that it's actuated at least in part by a purpose to serve the government. And what if the answer is you're both wrong? That you can't tell on the record that we have, because even drawing inferences in Ms. Carroll's favor, it's just a total blank slate. It's a black box about what Mr. Trump's motivations were. And we can make some inferences, but those inferences might cut in either direction, and we just can't answer that as a matter of law.
Well, I would respond.
You just don't think those are the facts here. I don't mean to jump ahead of you. I'm sorry to interrupt.
Yeah, I don't think that this is going to be an inflexible rule or result under the Westfall Act in the mine run of cases. I just think here you have two parties who both seem to agree that there are no material disputes of fact, and that all there is to do here is to draw inferences from those undisputed facts, at least as to the Westfall Act question. And so I suppose I would just say, I think it would be fair for this court to accept parties' invitations and the invitations of the Second Circuit to decide the case in the present posture. I don't think that there would be anything untoward about that.
Thank you, Ms. Van Zyl. Unless there are any other questions, we appreciate your arguments as the intervener in this case. Mr. Freeman, you have a few minutes for rebuttal.
Thank you, Madam Chief Judge. I'd like to start with Judge Easterly's questions. There were two for me, I think. The first regarding the validity of the Westfall Act certification. I think I can deal with this very quickly. There are just 2 points. The first is we certified on the basis of Ballinger. Ballinger expressly deals with the intent element under the restatement. Second, that was part of our consideration, and I can tell you that. But secondly, I don't think it matters because as it's common ground here that when a case goes to federal litigation, the plaintiff is entitled to argue that the certification was wrong and the government has to defend it. Second, Judge McLeese, I think this is the essence of where we've come after this whole conversation today as to what exactly how do we deal with this procedurally? I think you're right that there's the main question, as my friend put it, is whether, on this side, my friend put it, whether the allegations in the complaint on this procedural posture, whether the allegations in the complaint are sufficient to overcome the government's Westfall Act certification. Now, if the court is uncomfortable because of the lack of facts here, I think what the court could do is to say, as a matter of here's the answer to the DC law questions in this case. Now we leave it to the federal courts to decide whether the allegation is sufficient or the allegations in the complaint are sufficient to overcome the Westfall Act certification, given what DC law, as we've told you, its content.
Freeman, if we say as part of that we've treated these historically as fact questions, I guess this would have to go back to the district court judge for further factual finding. And that leads me to the discovery choices you've made in this case. Would you get a second bite at the apple on discovery to try and rebut the allegations of the complaint? Were we to send this all the way back?
So let me answer that in a couple stages, because I think there are a couple questions there. First, I think you would go back to the Second Circuit, and the parties would argue in the Second Circuit whether the complaint, in light of the content of DC law as clarified by this court, states is sufficient to overcome the Westfall Act certification. Now, my friend would have arguments that it needed to go back to the district court. The Second Circuit might agree with that. That would, I think, be the question. That's after all until the certification was ordered by the Second Circuit, that was the posture we were in. Now, second, as to whether there's been a forfeiture of any kind by the United States, I want to be clear about this. It is altogether common that the government does not put in facts in response in making a motion to dismiss or a Westfall Act certification. That's what the motion to dismiss stage is for. As Judge Deal explained, parties commonly think that a complaint on its face should be dismissed or should not be dismissed. And if the district court or the trial court doesn't dispose of the case at the initial stage, you move on. It's especially important in this context because there's an additional overlay of federal law, which I'm not expecting this court to address, but that has to do with discovery of the president. As a matter of federal law, the federal courts apply a very strict standard about when you can, for example, require the president personally to submit a declaration. And I'm not asking the court to address that question here, but just to realize that the application of the answer to the question that Mr. Matz identified, whether the complaint is sufficient to state a basis to overcome the certification or whether further factual inquiry would be necessary, would be informed not just by the face of the complaint, but whether as a matter of federal law, it is an appropriate basis to get discovery from at the time a sitting president of the United States. So that's, again, I think the procedural posture that we're in. And if the court concluded that the right solution to the certified question is just to tell the Second Circuit, look, here, what we understand to be the disputed points of DC law, here's our answer to the disputed questions of DC law. Please do with this as you wish. I think that would be appropriate. Then as to the disputed questions of DC law, from the United States perspective, in general, we don't take we come to we have employees in every state and the district and every territory. We take the law of respondeat superior as given. But given the question that this court posed, do we think anything requires clarification? I think it would be helpful to clarify two things. First has to do with is this any iota jurisdiction? And that's the question that I think Judge Shanker asked me earlier. I think it's a question that is amenable to some disagreement within the case law. I think the answer to that question is yes. I think that's how this court resolved the question in Blair.
Can I ask you about that? If we were an any iota jurisdiction, wouldn't we have cases making determinations as a matter of law about that something was within the scope of employment? Right? Look, it's the absence.
Right,
of
we're both
evidence.
inferring from the absence, yes.
But that absence seems pretty strong. I mean, there are just cases where you think this, seems like there could have been, there's a strong case to say that this was motivated, at least in part, to serve the employer. And yet we aren't making matter of law determinations in those cases. We send them to juries. And so I know that that's a procedural decision, not a substantive one, but it does seem to have a substantive undercurrent that we are not any iota jurisdiction. Do you disagree?
I do, although again, this is ultimately, we recognize this court's decision about the content of district law, but for what it's worth, I disagree with that the procedural facts that you enumerate reflect a substantive undercurrent. First, the way that cases like Blair have come to you is on appeal for a directed verdict for the employer. And so the plaintiff says, no, there are factual points to dispute that this was actually within scope. And so of course, the court on appeal from such a case doesn't reverse and order the directed verdict the other way. You just say, no, there are factual disputes. So I don't think you can infer from the procedural posture of those appeals. The second thing is you do have cases like Johnson versus Weinberg, the second case, that involve addressing jury instructions. Because of course, to the extent it's a jury question, they have to have jury instructions, and the jury instructions, I think under the law of the district, would properly state that someone is out of scope for an intentional tort if they acted solely for a personal adventure. And you would cite cases like Blair and a whole laundry list of other cases from this court for that proposition. So I do think this is an any iota jurisdiction, but to just because I realize we're near the end of the argument here, I want to be clear. I think that is a point that the court could clarify. The other point that I think it would be useful for the court to clarify as a matter of district law is what you were just discussing with my friend from the district, which is at what point do you measure intent? Do you measure it at the very moment that the tort is committed, or is Johnson versus Weinberg correct? And this piece was picked up in footnote 40 of Blair and has been a current through this court's cases, that you ask whether it arose out of a disagreement that was originally undertaken for the employer's benefit. Now, again, recognizing it's this court's prerogative to tell us what the content of district law is, not for me to tell you. I think my best understanding of the answer is that the court does at least measure intent a few seconds back from the moment that the tort happens. And I think—
Would you agree our cases are not consistent on that? Because some of them seem to expressly say, no, the question is purpose at the moment of the commission.
Right, you have cases sort of going both ways. And
why do you think winding the clock back a few seconds or whatever you think, however you would characterize this doctrine, why is it a good one? Why should we? If our law is uncertain, why is that the better answer?
So here's my answer to that question. Put aside the facts of this case in general. Of course, this is the highest court of the District of Columbia. You're thinking about, as you noted, intentional tort cases and the mine run of cases. Normally, right, by hypothesis, if we're in this posture and some intentional tort is alleged to have happened, an intentional tort, particularly if we're in category D using force, is often going to have been undertaken with a fairly vicious intent in that very moment. But it may have arisen out of a dispute over whether, for example, a customer was allowed to leave a store with free pieces of wood, as in Heckinger, or whether the cop in Blair started by saying, hey, I'm a cop, everybody chill out, and then ended up being criminally convicted for assault. If you ask the question just at the very moment the intentional tort begins, in many, many fewer cases are going to be within scope. And again, I'm happy to live with whatever the court says here. But normally, I think this court's case law reflects a desire to allow plaintiffs to recover from the employer when the course of conduct that led to the intentional tort was one undertaken by the employee with some desire to serve the employer, such that the employer bears some public policy accountability for that result. I think that's the policy through point in this court's cases, and I think that's why you've framed your decisions that way. But again, speaking from the position of the United States, we're comfortable with whatever outcome you
What's the
get.
policy rationale for that? So take the case where you're delivering the mattress, which is certainly within the course of the conduct of employment, but then it ends in an assault and a rape. Are you saying by shifting potentially the burden of that to the employer, is it because they have the deeper pocket? Because I think there's also an argument to be made of if you are properly policing your employees, they should not be doing that. And so they are on a frolic and detour when they are going to, in the moment, deviate from what's sort of standard operating procedure for engaging in their occupation.
Yeah, so a couple things on that. I think first, I'm glad you raised the distinction between a frolic or detour. I mean, that is how historically courts thought about that. A frolic was an entirely independent venture for which the employee is personally accountable, and a detour is one that, although you end up committing a tort, you originally undertook for the employer's benefit, and that's the historic basis for an intentional tort liability. I think the theory, recognizing the anomaly that the chief judge discussed with me earlier, that in this particular case, because of the downstream lack of waiver of defamation, that it isn't true. But as to federal law enforcement officers, for example, it would be. The reason for the policy reason is that the employer is in a position to train, mandate, threaten with the loss of a job anyone who allows their temper to get the worst of them, or goes on and then gets in a position where they go too far and they commit a tort. And the public policy of the respondeat superior doctrine is to recognize that in those circumstances, the employer ought not, in fairness, avoid liability. Now, again, I'm not the United States urging you to adopt that rule. I'm just explaining how I best understand the rules and why I think this court has answered those questions.
So along those lines, let me take you back to the control question that I asked before then. If this is occurring in 2019 and the best that the employer, if the employer is the American people, can do is wait for over a year to discipline, fire, or otherwise not rehire said employee, should that be changed? Should we be considering that and looking at it when we're looking at some of these quantums or just this analysis here at all? How does that factor in?
So neither we nor I think any party here is asking for a special rule for the president. I think I've been clear that I'm saying you should apply the restatement second, recognizing at 228 1A the content of the job. But I don't think that's what you suggest is the right question, Judge Howard. What the downstream employment consequences for the president are is sort of a question that is independent of the respondeat superior case law. Let me just take, for example, suppose you had a personal proprietorship in a family business.
What you're saying, and those consequences are separate. What I was going to is the answer you just gave, that part of the policy rationale behind this was the employer can train, prepare, give them standard operating procedures, discipline when they go out of line, et cetera. How should we take into consideration, or should we at all, the difference here, not with the president in particular, but any kind of employee that has an almost employer-like capability in setting their job duties?
It's not for me to say that there were direct political consequences for the former president for the conduct in this case or any other, but to the extent there's been a narrative about, isn't this how the former president operated? It wouldn't be surprising if some aspect of the political consequences that he faced were as a result of that general course of conduct. There is the law of respondeat superior set by this court reflects public policy considerations of a greater sort about the mine run of employees. And I agree with the comment so far that the Federal Tort Claims Act and the Westfall Act takes that law as given. So that's where I would leave the court.
I have one more question.
Yes, of course.
We've discussed the government's decision not to include an affidavit or any other sort of evidence at earlier stages here. I understand you're not asking us to conflate 1A and 1C.
Correct.
But is it your position that the facts and circumstances that inform 1A can do double duty and can also inform 1C? I mean, is that what you're asking us to do here?
So,
and you're not asking for a blanket rule for political officials. I understand that too.
Right. So I to be candid, it would be exceptionally rare in our view, speaking as the United States, for a president of the United States to be tortiously liable for a statement made in response to a press inquiry at the White House. Now, we think that's because Of course, a president in those circumstances is speaking speaking to the press, by hypothesis to the people in response to an allegation here that, for example, Ms. Carroll is quite clear, led to a media firestorm. So we think any president would answer that question, and we would expect them to do so, and that a tort arising out of that is at least in some part motivated by a desire to serve the employer. I agree that as a procedural matter, what we are doing there is inferring facts from the complaint, inferring arguments from the complaint, and we are essentially moving to dismiss, certifying on that ground, and they're making the opposite argument, that look at the things he said. This is the anomalous case in which you can conclude that there's not one iota of an intent to serve the public. That's the reason why, if the court is uncomfortable resolving that question, it's the reason why I said to Judge McLeese, I think what you could do is you could say, here's the content of DC law, and it is for the federal courts with the federal procedural overlay of the circumstances in which it is and isn't appropriate to seek discovery from a sitting president. It is for the federal courts to decide whether the allegations in the complaint are sufficient to rebut the Westfall Act certification.
Thank you, Mr. Freeman. Mr. Medeo, did I pronounce your name correctly, sir? Thank you.
For the record, Michael Medeo, on behalf of the appellant, Donald J. Trump, for rebuttal, and I'll try to be very brief. But the main thing that I'd like to address is there's been a lot of talk today about the court's role, and that the court doesn't want to distort any of the respondeat superior law for the case. And I think it's important to remember why we're here and what the Second Circuit said in their order. They admitted and acknowledged that Ballinger is on point. And really the only question was, it's not binding. So I think in terms of why we're here today, it's important for the court to, really all that's needed would be for the court to affirm and acknowledge that Ballinger got it right and that Ballinger did correctly apply the law of this state. And that's not going to.
So it seems like we're here for a second reason too, and that is Judge Calabresi spilled a lot of ink on whether we're a second restatement jurisdiction or an internalization jurisdiction. And in your reply brief, you suggested we were an internalization jurisdiction, but I understand your friend said that we are not. So do you have a definitive position on that?
I think there is, it's a fuzzy line. I think that the cases obviously go through the restatement test, but I think when you look at how they apply it, there is obviously an element of foreseeability and a lot of language of, conduct being an outgrowth of, a particular employee's job, which I think lends to a more of a reading of the internalization approach as opposed to the traditional restatement. And so to continue, I would just say that, again, I think this particular case is unique because it deals with, again, public officials, elected officials who have, a separate aspect of their position, which is not, you never have that with private employees, which is that they always deal with the public interest. They have.
You don't think that exists for other types of employees? I mean, what about a church leader or a leader of a union or, right? They speak to the public, they have a public facing role. Why do you think, elected officials, politicians are unique?
Well, because elected officials have obviously constituents.
Setting aside the president of the United States, which again, I think our court has very little interest in discussing the roles and responsibilities of the person who occupies that seat. But if you're talking about elected officials more broadly, why would I distinguish between, an elected official and say, a church leader or a union leader?
I think it comes back to the fact that, again, it's a democracy where they have constituents who, are voting, have to decide how to vote. Whereas, a church leader or some private employee, that would never be an issue. So I do think they're unique in that sense. And I think that.
So you agree with your colleague that as long as a public official is addressing a constituent, someone eligible to vote potentially at all for them, that they have carte blanche?
Not carte blanche. That's where I would again say that Ballinger did get it correct, because I think the circumstance is speaking to either the press or a constituent in response to an inquiry, so that they're, again, it's thrust upon them, similar to the holding in Blair, and that it's, again, a matter of public concern. So I think when you hit all three of those, I think that it is well within the scope of employment for an elected
So you
official.
think Ballinger calls for a carve out or special exception for public officials? Is that what you're saying?
No, I don't think it calls for a carve out. I just think that that is the most on point precedent that has dealt with this exact scenario, which again was acknowledged by the Second Circuit that this issue has already been addressed, and the DC Circuit obviously found that when a congressman, and again this obviously would apply to the president as well, when they're speaking to the press during work hours.
Is that what Ballinger says? Any congressman, anytime, anywhere? I mean, I thought Ballinger relied heavily on the fact that there was an affidavit from the congressman talking about, why he decided to speak to the press, right? He detailed explicitly, I spoke to the press for the following reasons. And then the DC Circuit block quotes what his reasons were.
Right, but I think in Ballinger also.
And then at the end of the opinion says, we're not articulating a blanket rule, right? Every case has to be decided on its own facts.
That's true, but I think the core holding of Ballinger is about the fact that congressmen and all elected officials, they have to maintain the public trust. That's part of their duty. That's part of their role as elected official. Maintain public trust and again, address issues of public concern. That's part of their role more so than any other.
So, but Counsel Ballinger also didn't explicitly, or at least Kerr and Ballinger didn't really challenge the purpose inquiry, did they? We had the affidavit, but I didn't see in that case when I read it, and perhaps I've just read it wrong and you can enlighten me, that Kerr didn't go to that didn't challenge and bring it to that second part of the analysis. And so Ballinger may be great for 1A, but it's really not helping us with C or 2.
Well, Ballinger again said it was an objective test, but I think that makes sense in terms of the context in which they were looking at it, because which again, I don't think this is a carve out, but I just think that given the particular circumstances of Ballinger and that we also have here, when you're dealing with a high ranking elected official, it's a fundamentally different analysis. So in that sense, it really is objective.
It's a fundamentally different analysis than the restatement second, than the District of Columbia's law.
In terms of private employee and the circumstances that are dealt with someone who is an employee of a laundromat or a retail store employee, I think it's fundamentally different when you're talking about somebody who is an elected official, somebody who has constituents, and somebody who is serving the country on behalf of their constituents and has a duty to maintain their trust. And
do you mean that the nucleus of facts, if you're talking about a public official versus a private citizen, might differ, but that the restatement second or the case law that we've been talking about today, the factors are the same, but when you look at the factual basis as applied to those legal standards, it might look different in the analysis. I guess I'm trying to.
Right, that's exactly. I think it's the
by
analysis, the factual analysis, I think, is where Ballinger really is the most on point. Because of course it's the same, it is the same principles of the restatement, but I think the way that they're applied was best illustrated in Ballinger. And I think that essentially what the Second Circuit was asking was, did they apply it correctly?
So then do you think that means if we were looking at it the way it was applied in Ballinger, that we should request an affidavit or request that the Second Circuit request an affidavit or send it back to the district court to get an affidavit or some additional facts?
I think, I read Ballinger more broadly where they, first of all, they say it's an objective test, and they also they say that sorry, I lost my train of thought there.
It happens sometimes.
Yeah, no, sorry.
Let me ask
So they say
you-
it's an objective test. And again, when you're dealing with a public official, that it's they have to maintain the public trust there. which is what separates it from the private employees.
In this particular instance, you have an explicit challenge to the motives and going straight to the purpose piece of the test. Do you, in your opinion, is it better to just get an answer now or to send it for fact finding? I'll say to get an answer now or to get it right. Like send it back for fact finding so we can be more sure.
I think we have all the facts we need based on, again, just the circumstances of what President Trump's role was at the time he was sitting president. He was at the White House. He was answering inquiries from reporters. It was a matter of public concern. And I think that alone satisfies all elements of the restatement test. So I don't think there's any need for any further discovery beyond that.
Thank you, counsel.
Okay, thank
We'd
you.
like to thank all counsel and parties for your briefs and your arguments today, and we will take the matter under advisement. Thank you very much.
All rise. This court is now adjourned